Good evening, everyone. I believe that I'm audible. So we will start the lesson straight away. So today's session is allocated for us to discuss the June 2023 paper, that is CL4. So here I will spend my time to discuss the answers or the solutions uh, to the questions given in June 2023. At the same time, I will be discussing the mistakes that students have made during that paper that is based on the examiner's comments, and the possible mistakes that you can make when you're answering questions, and the approach that you have to take when you're answering CL4 paper in CA. Right. So let me straight away share the screen. Okay. Can you see the paper?
Yes, sir, we
Someone?
can see. Yes, we
Yeah.
can see.
Right. Thank you. Now, it's the same format, basically. I don't think that I have to explain too much about the paper structure, but for completeness, let me give you a brief introduction to the nature of the paper that you're going to get at the exam. So it will consist of three main areas: Section 1, Section 2, and Section 3. You're aware that Section 1 consists of 10 MCQs, where they have allocated 20 marks. And then Section 2 consists of 4 questions. For each question, they have allocated 10 marks. Altogether, you get 40. So from the first 2 sections, you can score 60 marks. Then Section 3, you get 2 questions, and there for each question, they have allocated 20 marks. Accordingly, you can score 40 marks from Section 3. And you know that you have 3 hours and 15 minutes, that is inclusive of reading and planning. So within that time period, you can plan, you can read the questions, and at the same time, you can decide how you're going to answer the questions that you have been given. Anyway, you have to answer all the questions that you have been given. And apart from that, all of you are aware that CL4 is an open book examination. Accordingly, you're permitted to keep the Companies Act with you. So it's better you read the instructions now itself, rather than spending or wasting your time during the examination to read these instructions. But anyway, don't take a chance. There can be new instructions given by your examiner. Therefore, it's always better to read the instructions there. But you need to familiarize yourself with the instructions, because then you can save a lot of time and you can pre-prepare yourself for the exam. So I'm not going to read all the instructions given here. However, since this is important, instruction number 8 and 7, we'll go through it carefully, right? Instruction number 7, it says the examination will be conducted as an open book examination, and only the following publication will be permitted to be used at the examination hall. So it's an open book test. However, the only material that you can keep with you at the exam is number 7 of 2007 Companies Act. At the same time, candidates are allowed to bring or use the above permitted publications subject to the following: highlighting, sidelining, and underlining relevant sections in the publication are allowed. That's I would say, a blessing, extremely useful, because you will be able to save a lot of time by doing this. But of course, you can't do it at the exam. It's something that you have to do when you're preparing yourself for the exam. Short notes in the permitted publication are allowed. So you can have briefly, you can have notes written on the Companies Act itself. That is also extremely useful, especially if you have a problem of memorizing things, memorizing case law, then obviously it's a good opportunity because you can have short notes. Only if they are handwritten and are relevant to a particular paragraph or section in the publication which explains that paragraph or section. Any other notes written on the publication are not allowed. Attaching, pasting, or inserting any other document to the permitted publication are not allowed. Page tabs to refer the pages are allowed. So you can tab your pages as well. So for you to get through this paper, you need only two important materials. One is the Companies Act. The other one is your textbook. All the questions that you're going to get at the exam are based on your textbook. And you know, compared to other textbooks that you have for other subjects, this is relatively a very small textbook. You have 10 chapters, and the weight that they have given for each chapter is basically 10%. However, at least 7 chapters out of 10 are completely based on the Companies Act. But there are 3 other chapters. They are not based on the Companies Act. There are certain other statutes or acts which are applicable. In that case, those things you will have to memorize. That is because you are not permitted to take those statutes to the examination. You can only keep the Companies Act, but good 70% of your syllabus, they're based on the Companies Act. Therefore, you don't have to memorize anything that you get in the Companies Act, but you should know from where to find out the relevant section. So you can save a lot of time, but your pre-preparation is extremely important. Since you are permitted to highlight, sideline, underline, at the same time, you can write down notes. So when you're going through the textbook, if it is something relevant to the Companies Act, near the relevant section, you can write down notes, and then you don't have to memorize it. But you should know from where to locate them, from where to find them. That is extremely important. So you need to be familiar with the Companies Act, though you don't have to memorize it. Then you have 3 chapters, not based on the Companies Act. Sometimes it's based on the Land Alienation Act or Exchange Control Regulation Act. Then the listing rules are there. So, of course, those things are not mentioned in the Companies Act. Hence, you may have to, not may, you shall memorize those things. So that is very important because from those areas also, definitely you get questions at the exam because 30% of the syllabus consists of those 3 areas. So because of that, pay attention to those 3 chapters, those areas that are not based on the Companies Act. Spend a lot of time memorizing those areas. But if it is based on the Companies Act, you don't have to waste time memorizing it. However, make sure that you write down your notes on the Companies Act itself, right? So that will be useful when you're facing the exam. So these are little, I'm sure that you guys are already familiar with these things, but I thought that is my responsibility to mention these things again if you have not heard it before, right? Then straight away we will look at the solutions to these questions that you have been given, because that is the task that I have been given here, basically to discuss the paper. But when I'm doing that, as I mentioned at the very beginning, I will be explaining the comments made by your examiner also, because that will be useful to minimize your weaknesses. So when I'm reading a question, see whether you can come up with your own answer. It's better if you can write down the answer, whatever the thoughts that you have, the plan, the strategy that you have to answer those questions. And then when I'm explaining it, see whether it is in line with the solution or the answers that I'm giving. If not, make sure that you correct or rectify your weaknesses to improve your ability to answer these questions. I know this is an odd paper. You guys are familiar with calculations and financial or accounting related topics, but unfortunately, like it or not, it is part of your syllabus. And at the same time, I must tell you, it's there for a good reason, because even if you decide to become a company secretary, you may have your own a company secretarial arm, even though you intend to run your audit firm. So separately, you might be having company registration work, company secretarial work. So in that case, obviously, you must be familiar with these things. And plus, if you intend to become an investment advisor or in general financial advisor, obviously, you cannot avoid these laws. Hence, you must be familiar with it. So practically also, it will be important not only as a subject. Right. Now, first I will look at section 3. I will start with the last section. Now, why I decided to do that? You can have your own way of answering the question. So 15 minutes allocated for reading and planning. So there you can decide from which section you are going to start. Personally, I want to score as much as possible at the very beginning without waiting until the last moment. So section 3, I have to answer only 2 questions, but I can easily score 40 marks from that area. Therefore, I believe those 2 questions are extremely important. So I need to answer those questions as quickly as possible without waiting until the last moment. Therefore, my strategy is to answer and finish those 2 questions at once, because then I have secured 40 marks. I have covered 40 marks of the paper, 40% of the paper. So, timing is the next important thing. There, basically, let's forget about the 15 minutes reading time. We'll assume that we have only 180 minutes or 3 hours. So that means to score 1 mark, I have 1.8 minutes. Keep 15 minutes reading time as a bonus, right? As a buffer stock, as a safety stock, right? So we have 180 minutes. For each mark, I can spend 1.8 minutes. So here, question number 6 in section 3 gives me 20 marks. So I can spend 36 minutes to answer this question. To answer all 2 questions in section 3, I can spend 72 minutes. I can spend 72 minutes, 1 hour and 12 minutes. See whether you can answer within 1 hour. That should be your target. That should be approach. So see whether you can complete the section 3 questions within a period of 1 hour, right? So that should be the target. So let's read the question. Now here it says both questions are compulsory, obviously. Total marks for section 3 is 40 marks. And look here, recommended time for the section is 72 minutes. So make sure that you finish within 60 minutes or 1 hour. Now this is the question. I have this habit of reading the required part first, because at the end of the day, I have to answer these questions, nothing else. So first, I will get an idea what I have to or what I'm supposed to do here. Require. Explain to the shareholders of GG. I don't know what is this GG, what this GG is, but that's fine. It appears that it is a company. So leave it as it is. So you are explained to the shareholder of GG 5 instances that are provided by the Act where such a winding up is possible. It says such a winding up. I don't know the type of or the mode of winding up they are referring to. Now, when we are reading the question, to your mind, straight away, if you have gone through it, if you have studied properly, at once, you should start thinking, okay, what are the modes of or methods of winding up. So there are three types of winding up, isn't it? Winding up by court, voluntary winding up, that is voluntary winding up by shareholders, and voluntary winding up by creditors, twofold. So winding up by court is one method. Voluntary winding up is another method, but it has two ways of doing it. One is voluntary winding up by shareholders. The other one is voluntary winding up by creditors. Then the third situation is subject to supervision of court. So we have to read the facts of the question and figure out what is the mode of winding up that they are referring to. Let's see. Then B, 5 powers and duties applicable to RS. We don't know what RS is under the Act, if he is so appointed as the administrator of GT. So there's a key word here, administrator. So this topic is obviously from liquidation or winding up of a company. When it comes to liquidation or winding up of a company, there are two important areas, mainly liquidation. The other one is something called administration. So this question is from administration, but we need more information. Then the characteristics of both ordinary and preference shares that need to be considered when is invested. Actually, as accounting students, you should be able to give a very successful answer to this area. But I must tell you, if you read the comments made by your examiner, it's extremely disappointing. It's not satisfactory according to the examiner. So you can go through the comments made by the examiner. Those materials are uploaded to your website. So from there, you can download it. While I'm explaining the answers also, you can go through the comments. Some of the comments I will mention, but you need to go through it very carefully because that is how you can identify what your examiner expects from you. You shouldn't write what you want at the exam. The best way to get through your CA papers, not only this paper, even other papers, I'm telling you this through my experience, though I'm here before you as a lawyer explaining this. I'm also having an accountancy background. I'm a member of ACCA. I believe that you have heard about it. So that's another accountancy qualification. So I know when it comes to any accountancy qualification, when it comes to any paper, the success, the secret of getting through any paper, you have to answer according to what your examiner expects from you. You have to always understand the expectation of your exam. If you answer accordingly, you can freely score marks without any problem. You can freely score marks. Therefore, please go through the comments made by the examiner. I will also mention. So what I want to tell you, this appears a very straightforward question. And look at the number of marks allocated, 10 marks. But the examiner says, the students have not been able to score satisfactory. There are a lot of mistakes students have made, even when it comes to a question like this. So you have to read it carefully because the examiner's one complaint is, continuous complaint that he has made in his report is that students have not answered the requirements of the question. Instead, most of the students have answered what they want. Sometimes unnecessarily wasted time, according to the examiner, explaining things which have not been asked. So you shouldn't do that, right? So you have to, this is what, hard working is important, but smart learning is extremely important when it comes to a paper like this. Okay, now we'll read the instructions given here. Yasat, Dimut, and Kamal are the shareholders of GG Private Limited. So there are 3 shareholders. This is the company. Hereafter, it's known as GG. A company incorporated under the Companies Act number 7 of 2007. Hereafter, known as the Act. GG's Articles of Association states that if the company is to be wound up, it must be done by, okay, Now, when you are writing the answers also, second. Right. Let's see. GG's articles of association say that if the company, so articles of association, this is the most important document of a company. We call it the constitution of the company. Like we have a constitution in this country. We say the supreme law of the country is the constitution of this country. Supreme law of a country is the constitution. All the other laws are subservient, subordinate to the constitution. Likewise, in a company also, the officers of the company and the company itself must always comply with the articles of association because it's the constitution of the company. It says if the company is to be wound up, it must be done by the courts. So here I explained at the very beginning, there are three modes of winding up: voluntary winding up by court order, and subject to supervision, the third part. Here they are referring to winding up of a company by a court order. And money remaining after paying the company's creditors is to be divided among its shareholders. Even though they don't mention this, you are very well aware as accounting students, once a company is liquidated, first you have to, when a company is liquidated, first you have to settle all the external liabilities. And after that, if you have any remaining funds, those funds must be distributed among the shareholders of the company. The shareholders also intend to propose to the court to appoint Rex Dicerum, RS. RS is Rex Dicerum, is an individual, as the administrator in relation to this winding up. As administrator in relation to this winding up. So that is where you get the administrator. Further, the shareholders have also proposed to invest whatever surplus of cash that may be realized from this winding up. That's nothing to do with this actually. Once the winding up process is over, then there will be some remaining funds. So these three shareholders have decided once the company is wound up, whatever the surplus cash that they have, they are going to use winding up in the shares of a newly incorporated company dealing in motor spare parts. So once this company is once the company is wound up, whatever the excess funds they have, they will use to incorporate a new company, and the business of that new company would be dealing in motor spare parts. They are considering investing in both ordinary and preference shares. Now you will see when you read the required part here. When you read the required part, you will see that the first question is actually based on this paragraph. 5 instances that are provided by the Act, such winding up is possible. 5 instances that are provided by the Act where such a winding up. What is such a winding up here? That is winding up by court order. Such a winding up by court. Then the second question is based on this one. 5 powers and duties applicable to RS, that is Rex Dicerum. They're going to appoint him as the administrator. Powers and duties applicable to an administrator, that is based on the second paragraph. Third question is based on this paragraph. That is investing in both ordinary shares. What do you have to explain? What do you have to explain there? The characteristics of both ordinary and preference. What do you have to explain? Characteristics. your examiner has said most of the students have failed to explain the characteristics. And when it comes to powers and duties, I mean, the answers are there. You can even go through it. But I am here to explain some additional things to minimize your weaknesses at the exam, minimize your mistakes. The examiner says, when it comes to powers and duties of an administrator, some students have wasted time explaining the role of the administrator, the definition of an administrator, and some students have wasted their time explaining the rights of an administrator. They haven't asked any of those things. You have to list down 5 powers and duties. That's it. 1, 2, 3, 4, 5. You don't have to unnecessarily explain things that have not been tested here. Then here also 5 instances that are provided by the Act. By the Act. Then do you have to memorize this? No. You should only be able to find out the relevant section of the Companies Act where you can find out the instances where a company can be wound up by a court order. There is a specific section in the Companies Act. If you can find out that section, then obviously it's just a matter of copying and writing on your answer script. You can easily score 5 marks. So now we will look at the answers to these questions. So let's look at the relevant section here. That is in the Companies Act. Take the Companies Act. I want you to have the Companies Act when I'm explaining this actually. Okay, one other thing. Be familiar with this index. Again, can save a lot of time. But you can't do this at the last moment, one day before the exam. That's why you need pre-preparation. So look here. Table of sections. Table of sections. So be familiar with these sections, the relevant chapters. Just read them. Here about articles of association. Then when you go, so you have the relevant heading. You have the relevant heading. Now, when it comes to winding up of a company, you will see okay, here. Now you can see right. Let me winding up chapter part 12 of the Companies Act on winding up. Here, modes of winding up, but all these things are not relevant straight away. We should be able to find out the relevant section. Here, winding up by the court. Here you have the answer. They're asking circumstances, the instances where a company can be wound up by the court. You just have to find out this section and repeat that section in your answer booklet. You can easily score 5 marks. So now let's look at what you get there. Okay, so here, this is the relevant section. A company may be wound up by the court if, so what you have to do, write them down. 1, 2, 3, 4, 5. There are 6 here. They have only asked 5, but if you want, you can write all 6. Did you have to memorize it? No. The only thing that you had to be familiar with was you should be able to find out or locate the relevant section. So that you have to do while you're studying for the exam. So these are the 5 instances. If the company has by special resolution resolved that the company be wound up by the, so if they have passed a special resolution, you know, there are different types of resolutions: ordinary resolutions, special resolutions, circular resolutions, or resolutions in lieu of, resolutions in writing. Resolutions in writing. So, you know, if it is a special resolution, you need 75% or more. Not important. You just have to write down these 5. Additionally, if you want to have 6. Second one, the company doesn't commence its business. You have incorporated the company. For 1 year, you haven't started or commenced your business activity. Or else already incorporated, but for 1 year, you have not been doing any business. Suspends its business for 1 year, then you can obtain a court order to wind up the company. If the number of the members falls below the minimum number of required under subsection 2 of section 4 of this act. If you go to section 4, subsection 2 explains the minimum number of shareholders that you have in a company. If it is a private limited company, you know, it's only 1. However, so that means you can have single shareholder companies. But if it is public or company limited by guarantee, you have to have at least 2. Then, so if the number of shareholders have gone below the minimum number of shareholders required, you can obtain a court order to wind up the company. If you have come to a situation where all the directors have resigned, the company has no directors, you can obtain a court order to wind up the company. The company is unable to pay its debts. There is a definition given here, but that is also not important. Don't waste your time. You just have to write down this. The other one is the court is of the opinion that it is just and equitable that the company should be wound up. So if you write down these, extracting from relevant section 270, you score 5 marks. You guys are mature students doing a very serious examination. It's a professional qualification. You're going to be a chartered accountant. And if you are telling me that you cannot do this simple thing, identify the relevant section from the Companies Act and reiterate in your answer book, then there's something seriously wrong. So you have to make more effort. If that is the situation, it's just a matter of locating the relevant section from the Companies Act and writing it. And even if you look at the, at the same time, I'm looking, yeah, good. You are sending some questions also. Do we have to write the relevant section or can we write as subsection 2 of subsection 2? Yeah, so I believe point 3, I believe that do we have to write the relevant section or no? Even the examiner has said if you have not been specifically asked, there's no reason to write down the relevant section. But if you feel good, no harm done, you can mention as per section 270. These are the instances where a company can be wound up by court order. Don't try to explain any of these points. Just write them as it is more than enough. Because they have just asked you to list down them. So why you waste your time doing something that they have not asked? So you shouldn't do that. Right. So 5 instances that are provided by the Act. So it should be there in the Act. It should be there in the Act. So that is the answer to that question. Right. Then we will look at the next question. Let's see. 5 powers and duties applicable to RS, who's going to be the administrator of this company, if he's so appointed as the administrator of GG. Right. Powers and duties. Again, from where can we locate it? We can find out powers and duties of the administrator from the Companies Act itself. Now, you can't do this at the exam, but to save time, I will search, then it will be easier. Here, administrators. Appointment of administrator. Are you going to waste? You should not waste your time to explain this. You should not waste your time to explain any of these things. The question is very clear. They have asked you to identify the powers and duties. Powers and duties. By the way, if you want to find more information in your textbook, everything is in the textbook. The questions will be based on the textbook. So actually, you don't have to read anything else. Just be familiar with the textbook, right? Okay. If you go to study text pages 104 and 105, you can find more information about this winding up by a court order, right? Then, powers and duties of an administrator. This is power of board to appoint an administrator, so not relevant. And the examiner has said some students have spent time explaining the qualifications of the administrator. Any of those things are extremely irrelevant. So you should not waste your time. Now we come to the relevant part. Powers of an administrator. So here, the answer is here. You can see powers of an administrator. Again, sometimes you will have to change a bit when you're writing the answer, when you make it suitable to the question that you have been given. So, but basically here you can reproduce this. The first one, the administrator shall manage the affairs, business, and property of the company. They have asked you to give 5. Then, do all such things as may be necessary or desirable for the management of the affairs, business, and property of the company. Then, this is another power. Without limiting the power specified in paragraphs, so here you can say you have to be little careful. You have to use your common sense when you're reproducing something, right? So if you have said 1 and 2, then don't say A and B. You can say third one without limiting the power specified above. Specified above in 1 and 2 shall have all the powers that could be exercised by a receiver of the whole of the property or undertaking of the company. No need to mention these. So that's why you have to use little bit of common sense and reproduce in such a way that it is suitable or appropriate to the question that you have been given. So they're asking the powers, so you can reproduce it in this particular way. It has to be, whenever you reproduce it, it should give a proper meaning. So then you don't have to reproduce this part and you can use the balance part and answer the question. So that is the third part. Then there's another power given to administrator. He can apply to the court for direction in relation to any matter arising in connection with the carrying of his function. That's another power given to the administrator. All these are powers. This is a limitation to the power. So here you can see we have 3 powers provided in number 1. Apart from that, we can identify this as the 4th one actually. Then if you look at 3rd one, that's why you have to be a little careful when you're reproducing. The 3rd one is a limitation that you have been given. It's more than a power. It's a limitation or restriction on the power that you can deal with. And look at this one. The administrator of a company may dispose or otherwise exercise his powers in relation to any property of the company which is subject to a security. This is also a power. This is also a power. And here, if you look at the question very carefully, you will see they are asking powers and duties, both powers and duties. So there were 3 powers that I mentioned earlier. These are the duties of the administrator here. Shall take into his custody or control all the property to which the company or appears to be entitled. He shall manage the affairs, business, and property of the company. So actually, when you're answering the question, since they're asking about both powers and duties, there are 3 powers mentioned in the previous section. You can write them. Those are the powers. And then duties you can identify from section 418. And you can write down these duties here. So there are several, but you have to write only 5. So again, it's there in the Companies Act. You have the Companies Act with you at the exam. You just have to find the relevant section and reproduce it in an intelligible manner. You can't just copy and paste. You should know whether it is relevant or not. So as I mentioned, some of the sections are not relevant because they have a restriction on powers. But that is not what they're asking. What are the powers and duties of an administrator? Don't waste your time explaining who is an administrator. So there are 3 powers and there are several duties. Just mention 2 of them. That is more than enough. Now, before looking at the comments made by the examiner, let's look at the answer to the third question also. The characteristics of both ordinary and preference shares, I believe from O-level days, if you have done commerce O-levels, if you have done accounting, business studies for A-levels, obviously you have learned the difference between ordinary shares and preference shares. But unfortunately, the examiner has said most of the students still have failed to give satisfactory answers. Main issue is you guys don't read the questions very carefully. The characteristics of both ordinary and preference shares that need to be considered when investing. Characteristics. So what you should do here is explain the characteristics of both ordinary shares and preference shares, nothing else. So when it comes to an ordinary share, basically the ordinary shareholders are the real shareholders of the company. We are asking, assume you have bought an ordinary share. What are the characteristics of an ordinary share? Basically, the ordinary share gives the owner, the shareholder, ordinary shareholder, 1 vote per share. 1 share, 1 vote. It's in the Companies Act also. It's in the Companies Act also, but you don't have to mention the relevant section. But I am actually referring to the Companies Act. The sections very clearly says, if you're an ordinary shareholder, you get 1 vote per share. And then equal dividend. the ordinary shareholders can participate equally in dividends. If I have 10 ordinary shares, A has 10 ordinary shares, B also has 10 ordinary shares, both of them should get the same dividend amount. For each ordinary share, they allocate a particular dividend amount, or it can even be a percentage that must be given to each ordinary shareholder. So they can participate equally in dividends. And the other thing, so these are the characteristics. One vote per share can participate equally in dividend. And another characteristic that you guys have already learned when you were doing A levels also, I'm sure, that is when you wind up a company. I mean, I don't have to explain these things. You guys are familiar with it. Let's assume you have 100,000 rupees in the company, the assets value. Liabilities, let's assume you have 40,000. Then there is a balance of 60,000. Who's entitled to this 60,000? Who's entitled to this 60,000? Ordinary shareholders. Ordinary shareholders of the company. So when you wind up a company, ordinary shareholders have unrestricted participation in, unrestricted participation in the balance remaining funds of the company. First, you have to settle the liabilities. That's the law. After settling all the liabilities, whatever the remainder should be distributed among all the shareholders. There is no restriction whatsoever when you're distributing the balance of the company. That's why we call it equity, owner's equity or shareholders' funds. Ordinary shareholders, not other shareholders, ordinary shares. So unrestricted. And even if the company has profits, unrestricted dividend. Is there any restriction when it comes to distribution of profits among ordinary shareholders? No. If the company has profits, company should have profits. I'm asking you this question, answer. If the company doesn't have profits, that means company has incurred losses. Can the company pay dividend to ordinary shareholders? Is it possible? Someone can mention your answer. I mean, you can mention your answer in the chat room. What do you think? Can you pay dividend to ordinary shareholders if the company doesn't have profits? Yes, I am getting the answer. No. Very good. Yes, you can't. But if the company has profits, we call it distributable profits. If the company has distributable profits, of course, no restriction whatsoever, even the full amount you can pay as dividend to ordinary shareholders. But if the company has losses, if the company has no distributable profits, it's illegal to pay dividend to ordinary shareholders. So those are characteristics. So that's a risk basically. If you have profits, unrestricted distribution of dividend among the ordinary shareholders, provided the company should have distributable profits. If not, ordinary shareholders are not entitled to any dividend. That is the risk that they take, but we don't have to discuss, but it's a characteristic. So one vote per share, participate equally in dividend distribution. If the company is wound up, the shareholders are entitled to the remaining funds of the company unrestricted, and then the ordinary shareholders are entitled to, or they have a right to, unrestricted participation in the dividend of the company, provided the company should have enough distributable profits. Otherwise, it's not possible. All right. Then what about the characteristics of preference shares? You need to write them separately. So the characteristics of ordinary shares, characteristics of preference shares. Preference shares, from the name itself, from the term itself, you can understand they are given the preference. That is, preference shareholders are not entitled to unrestricted dividend, but they're entitled to a fixed dividend. They're entitled to a fixed dividend, and they should be given priority over ordinary shareholders. So when the company is paying dividend, first they have to pay the preference shareholders their fixed dividend, and then you can pay the ordinary shareholders if you have any balance. So the priority, the preference must be given to the preference shareholders. And even when you're winding up a company, their capital must be returned first before the ordinary shareholders. So the preference shareholders are entitled to receive their capital before the ordinary shareholders. That's why we call it preference. When you're paying dividend, when you're returning capital, preference must be given to the preference shareholders prior to the ordinary shareholders. If there is a dividend, fixed dividend, it must be paid to them. So the preference shareholders, as of right, entitled to a fixed dividend. If the company is not in a position to pay this year, it can be paid next year. Accordingly, it can be categorized as cumulative preference shares and non-cumulative. If the dividend is not paid, it can be added to the next year, then you call it cumulative. If it is not added to the next year's amount, then it's non-cumulative, right? And the other thing is, ordinary shareholders, they are the real owners. So when they invest in a company, they take a huge risk. The company has no obligation to return their money. Company has no obligation to pay dividend to ordinary shareholders. But preference shareholders are not like that. You have to return their capital before ordinary shareholders. You have to pay their fixed dividend. Apart from that, normally when the preference shares are issued, at the very beginning, the company and the shareholders enter into, the company will specifically mention the terms and conditions of the preference shares. That is because there are different types of preference shares, as I mentioned earlier: redeemable, irredeemable, cumulative, non-cumulative, right? Contributory. Likewise, there are different types of preference shares. Therefore, at the time of issuance, the company will specify these are the terms of the preference shares that you're going to purchase. They will say this is your fixed dividend and these are the other rights that you have. So normally that will be disclosed at the time of issuance. So these are the characteristics. I'm not going to do this for each and every question because it's available, but for you to understand, because I, of course, can't understand why students make mistakes when it comes to straightforward questions like this. But unfortunately, look at the examiner's comments on these three questions that we already discussed. Okay. Question number 6, overall performance of this question was satisfactory. All three parts of the questions were straightforward. Absolutely. 20 marks. This part required candidates to mention 5 instances provided by the Act where a winding up by the court is possible. Most of the candidates answered part A well and obtained the full marks allocated. Some candidates wrote the procedure of winding up a company by court. When the question clearly says the instances where a company can be wound up by a court order, why you waste your time explaining the procedure of winding up a company by a court order? Simple understanding, or simple, reading the question carefully will save your time, and plus making blunders like this. B, this part required candidates to mention 5 powers and duties applicable to RS under the Act if he is appointed as an administrator. Most of the candidates provided the correct answer for this part. However, common mistakes observed in the answer were the following. Look here. Some candidate provided details of the appointment procedure of an administrator. Where have they asked you to explain that? No. But even you might be thinking it's a little funny, but this is what students have done at the exam. Some mention the powers of a liquidator. When it says an administrator, that is because you haven't done your homework. There is a clear difference between a liquidator and administrator. Administrator is normally appointed to see whether the business can be revived. The liquidator straight away wind up the business. But here, before winding up the company, sometimes you make an attempt to figure out whether you can revive the business. That means it's like this. There can be situations like this. If you wind up the company now, most of the liabilities will not be settled because the company has gone bankrupt. Most of the liabilities will not be settled. But without winding up immediately, you can appoint an administrator for a short period to revive the company and to generate more assets for the company, better prospects for the company, and then go for liquidation, because at that point you will be able to settle more liabilities than what you can settle right now. So sometimes you can do that also. So for that purpose, you may sometimes for that purpose, you can basically appoint an administrator. He will try to manage the business, manage the properties of the company to make it little favorable, beneficial to the creditors of the company, and then go for liquidation. Perhaps you might be able to even continue. So there is a clear difference between a liquidator and administrator. If you don't know the difference, then you make mistakes like this. Then here, selling movable and immovable property. Then it says, this recording will be shared. I mean, CA will share these recordings within the next week, hopefully, and I will also inform them to upload this. Some candidates mention the role of a receiver instead of an administrator. Now, why do you confuse yourself? That is because you have not learned the subject properly. Administrator is different. Receiver is different. Liquidator is different. If you look at the definition given of a receiver, is a court officer appointed by court. Sometimes until such time you appoint a liquidator, temporarily you appoint a liquidator, we call that person the receiver, court appointed, but completely different from an administrator. So when they have specifically used the word administrator, why you explain the rule of a receiver? I do not understand. Some mention the rights of an administrator instead of powers and duties. When they have specifically said powers and duties, again, I don't understand why you explain about the rights of an administrator, right? So these are the common mistakes that students make at the exam, though you think that you have faced the exam very well, right? This part C. I'm not going to explain about the comments of the examiner one by one, but I just wanted to point out the serious mistakes, stupid mistakes, I would say, that students make at the exam. Unnecessary. These are called blunders. This question required candidates. This question required candidates mention the characteristics of both ordinary and preference shares that need to be considered when investing. Most of the well and obtain the full marks allocate. Other common mistakes. Look at here. Some misunderstood the question and wrote the common features as an answer. No. Characteristics of ordinary shares, characteristics of preference shares. Why do we explain common features? Some answers mention the matters characteristics to be considered when investing in ordinary preference shares. For example, whether there is enough security for the investment. I don't know from where it comes from. When the question is so straightforward. Operational performance. I think our CA students are too intelligent. Because when the question is straightforward, they're explaining something extremely complicated actually here. Whether the company is solvent or not, right to vote, completely relevant. Some explain the different classes of shares. I told you cumulative, non-cumulative, redeemable, irredeemable. Have they asked that? No. Some wrote all characteristics of shares without separating them. Characteristics of ordinary shares, characteristics of preference shares. A considerable number of candidates wrote of Section 49. No harm, but it was not required because these characteristics are set out in Section 49. But since they haven't asked, it's not necessary for you to write them down. All right? Okay. Then we'll go to the next question quickly. Right. So, required. Okay, so there's a question asked now here. It says 10 marks. 10 marks. No, I mean, you don't have to write 10 items because look at the compare. First two, A and B specifically, they say 5 instances, 5 hours and duties. Then you have to five at least 5. You have to have 5. Third one, are they referring to a number? No. That is because you can't have 10. You can't have 10. So here in a situation like this, if you can explain 3, 3, even that is enough. Right? So you don't have to. If you can find 10, of course, do it. But if you can't find 10, obviously, in a situation like this, you can't. So maximum 7, 8 here. So in that case, you can mention that. But if they specifically said 10, yes, then you have to give 10. Right. How a notarily execute, I'll say, okay. 5 disqualifications imposed by Arjuna. Okay. Right. First, we will read the information given here in this question, considering so need to save time also. Might be really, it's a Friday evening. Love to relax, and some people, I think, having some exams also tomorrow. So anyway. Ernest Mapa, EM, and Malik Jesudasan, MI, are two of the most active shareholders of Quick Freight Private Limited, QFL. A meeting of QFL shareholders was called to discuss the following matters. The procedure that the company must follow according to the Companies Act, number 7 of 2007, when entering into a signing a contract. Again, it's there in the Companies Act. The appointment of Arjuna as a new director to the board of QFL. As some shareholders didn't attend the meeting citing the high cost of transport, EM wants to know what the quorum is and its effect on a shareholder meeting. Shane, the company secretary of QFL, informed the shareholders present that QFL has adopted the model articles. Right. Then MJ, a shareholder of the company, MJ, a shareholder of the company, is asking, in turn, requested Shane to recommend a solution for having future meetings in more effective manner. Why? Though you have 2 active shareholders, most of them do not attend the shareholder meeting, saying that they can't, citing the high cost of transport. So he's asking the company secretary a solution for having a future meeting in a more effective manner. Shane immediately suggested that the company can follow the resolution in lieu of meeting, circular resolution. These are the key words. There was this word called quorum, and then signing a contract by a company, appointment of a new director. They have adopted model articles. So the company's constitution is based on the model article. So these are the key areas that you have to identify or highlight when you're answering this question. Right. Then let's look at the questions that we have been given here one by one. How a notarially executable contract can be entered into by QFL. Notarially executable contract. I'm not going to explain the whole history. Now, a company is also a person. We call it a legal person. So like us, we are individuals, we are human beings. We can enter into contracts. We are adults. So when we go to a supermarket, when we purchase something, we enter into a contract. When I buy a land, I enter into a contract. But when I go to a grocery or supermarket and purchase goods, it's a simple contract. When I even buy a phone, it's a contract, maybe written, maybe orally. But when I buy a land, then it has to be in writing. So it has to be in writing, plus it has to be notarially attested. A notary public, most of the lawyers do this job. A notary public, notaris, he has to attest the document. We call it a deed. Go and look at your deed of the deed that you have for your property, for your house, right? And there on the last page of the deed, you can see something called attestation. Attestation. It's not the time for me to explain the subject, actually. I have to just explain the answer. But that is what we call a notarially executable contract. Not every contract has to be notarially executed. Some contracts even can be verbally. I mean, some contracts are verbal contracts. You don't have to have a written document. Some contracts have to be in writing. Now, if you are even transferring or selling a motor vehicle, it has to be done in writing. So that's why you have to go to the RMB and submit the relevant forms, and it has to be done in writing. But when you're buying a land, not only it has to be in writing, it has to be attested, certified by a notary public. We call them notarial executable contract. So they are asking, what if a company wants to buy a land? That's the example we have to take, because that's the place where we have to get the document notarially attested. We call it deed of transfer. Deed of transfer. So if a company is buying a land, or if a company is selling a land, what is the procedure? Now, if I am buying a land, if I'm selling a land, I can sign the deed of transfer because I'm an individual. I have a signature. But if the company is selling a land, can the company sign? Company, though it's a person according to the company law, that's the very first thing that you learn at the beginning of the subject. Company and the shareholders are different. Company is a separate person. Salomon versus Salomon and Company Limited. Company is a separate person. That is what we learned under Salomon versus Salomon and Company, Lee versus Lee's Air Farming Company Limited, Makora versus Northern Assurance Company Limited. So in all those cases, you learn the company is a separate person. Company can enter into contracts. But the thing is, company, unlike us, it can't sign. It's not a real person, though it's a legal person. Then who should sign on behalf of the company? That is what you get in the Companies Act. Who should sign? Normally it says 2 directors have to sign, but there can be companies you have only 1 director. Then that director should sign. 1 is enough if you have only 1 director. Sometimes there can be situations you can delegate the signing power to some other officer in the company. You don't have to have directors, but you can delegate it. Now, that is what you can find in the Companies Act. We will look at it in a while, the answer to this question. So, how notarially executable contract can be entered into by QFL per the Act. So, let's look at the answer. Right. In the Companies Act, here, company contracts, section 19. The answer is here. You can score 5 marks. Method of contract. Here, the answer is A. You can find the answer in 19(1)(a). Let's read it and see. A contract or other enforceable obligation may be entered into by a company as follows. Since the company is not a human being, it cannot sign like we do. Therefore, as a legal person, how a company can enter into a contract. In particular, if the contract is a contract which is required to be executed notarially. An obligation which, if entered into by a natural person, is required by law to be in writing, signed by that person and be notarially attested. So if the law, who's a natural person? We are natural persons. We human beings are natural persons. We can talk, we can think, we can sign. So if a natural person is required by law to be in writing, signed by that person, when I am selling a land, I have to sign the contract. I have to sign the deed as a natural person. Then if a company is also doing a similar transaction like a natural person, it has to be done by the directors of the company. May be entered into on behalf of the company in writing, signed under the name of the company by 2 directors of the company. But if you have only 1 director, if there be only 1 director, by that director, so you have to just, you can reproduce it. You can shorten it if it is too long, but otherwise you can just reproduce the same thing. If there be only 1 director, by that director, sometimes the directors may be abroad, so you can't find directors. Then, if the articles of the company so provide by any other person or class of person. So, the articles of association says, in the absence of directors, the senior manager, general manager, or the company secretary can sign. Then, they also can sign on behalf of the company. Or 1 or more attorneys appointed by the company. Sometimes there can be situations you appoint a person by a power of attorney. Don't think too much. You just have to reproduce this. That's all. And be notarial executed. So you're selling your land. The company is selling their land. Then you have to do a deed of transfer. In that, if you have 2 directors, those 2 directors can sign. If you have only 1 director, that 1 director can sign. If the directors are not available, you can assign some other person as specified in the articles of association. If the articles do not provide names other than the directors, then the company can authorize some other person other than directors to sign the deed of transfer by a power of attorney. And then a notary public should do the attestation here. It should be notarially executed. So this is what you have to reproduce. You don't have to even mention the section. However, the content of the section you have to mention. So how? In this instance, how a notarial executable contract can be entered into by QFL by per the Act, right? So, unlike other subjects, again, I'm telling you, with my experience in accountancy also, this part of the world, countries like us, students always make mistakes when it comes to papers where you have to write a lot because we have language barriers, we have communication issues. So whatever the thoughts that you have when you try to articulate them, when you write it on a piece of paper, on the answer booklet, sometimes you can't express it properly. That problem is there, especially when it comes to papers like this. However, good thing is most of these words, sentences, the language you can use a language in the Companies Act as it is. So your focus should be on studying the textbook, understanding each and everything, and cross-reference with the Companies Act. And now there are certain things not mentioned in the Companies Act, but mentioned in the textbook. Then what you should do? Go to the relevant section, make a short note near the relevant section. So even though it's not in the section, but still in the textbook, but you import that to the Companies Act. Let's say section 19, subsection 1. Now there, if you go to page 35 of your study text, it explains. So there can be additional stuff not stated in the Companies Act, but relevant to section 19. Then what you should do, don't be lazy. Extract that, shorten it, and write it near section 19. So then you have the Companies Act and the short note extracted or short note that you have prepared based on the textbook. But you can't take the textbook, but the note you prepared based on the textbook can be written on the Companies Act near the relevant section, which is a blessing. So that is one way of boosting your confidence. If you find it difficult to write answers or articulate sentences, writing sentences, if you have that problem, this is what you have to do. So hard working is extremely important in that situation, right? Then, because sometimes you might be wondering what do you mean by notarially executable, because these are legal terms. So that is why you have to go through the textbook very carefully. Then the second one, 5 disqualifications imposed by an act that Arjuna should not have. Now very carefully read it. Because again, I can remember the examiner has said, some people have written qualifications of a director. Here what they say is that 5 disqualifications imposed by the act. Who's Arjuna? Arjuna is going to be appointed as a director of the company. So the disqualifications Arjuna should not have, in order to be eligible for appointment as a director. So what you have to find out is, go to the Companies Act, figure out what are the disqualifications. What are the disqualifications? So let's see. There is one whole section explaining or setting out the disqualifications of a director. I mean, is it something difficult? Because you're not doing a simple exam, right? It's a highly professional exam, right? You know the difficulty of getting through. But when you have the opportunity to write answers in this particular way, if you fail to exploit those opportunities, that's very unfortunate. Right. So let's see. If you can straight away figure out where the section is, you save a lot of time. But if you try to do this at the exam, then that's not the correct approach that you should take. Right. Okay. Here, the disqualification of directors. Second, guys. Right. Here it says true qualification of directors. Any person who's not disqualified under subsection 2 may be appointed as a director of the company. That means if you are not disqualified, you can be appointed as a director. So subsection 2 gives you a list of disqualifications. If you have one of these, then you're not qualified or suitable to be a director of the company. What are those? A person who's under 18 years of age. They have asked 5. You have to. There are several. Just reproduce 5. A person who's an undischarged insolvent. Don't think too much about it. These are, technical stuff. That means you are a person who has gone bankrupt, basically. Then you cannot be appointed as a director. Whether you understand or not, doesn't matter. Disqualifications are here. They are listed under subsection 2 of section 202. Just reproduce them. A person who is or would be prohibited from being a director or being concerned or taking part in the promotion, formation, or management of a company. Though you don't understand a word, it doesn't matter. It's a disqualification. Write it down. A person who's prohibited from being a director or promoter or being concerned or taking part in the management of the company, write it. A person who has been adjudged to be of unsound mind. A crazy person cannot be a director of the company. So there are 5. And here they have asked you to reproduce that. Okay, right. So they have asked 5 disqualifications. So don't waste time explaining these disqualifications. You just write them down. Then the third one, to EM the answer to his queries, taking into consideration the statement made by Shane regarding the model articles. What is that? What about this one? There's a question asked. What is the question? As some shareholders did not attend this meeting, citing the high cost of transport, EM wants to know what the quorum is. What do you mean by the quorum? Someone give me the answer. What do you mean by the quorum? Can someone give me the answer, please? That is part of the answer. Quorum. If you don't know the word, then you're not going to get full marks for this. Quorum. You guys will become directors, shareholders of companies. So then obviously you should know the terminology, the technical jargon. So here, quorum is okay, doesn't matter. Quorum means the minimum number of shareholders who have voting rights should be present at a meeting to have a valid meeting. Now, when you're starting a meeting, we say there should be a minimum number of members. Without those minimum number, without satisfying the quorum requirement, you can't have a valid meeting. Now here, this company secretary says the company has adopted model articles. The company has adopted what? Model articles. Where can we find model articles? You don't have to worry. It's given in the Companies Act. It's a annexure to the Companies Act. It's an annexure to the Companies Act. It's a schedule, the first schedule to the Companies Act. You know, there are 13 schedules. to the Companies Act. The first schedule is the model articles. I'm not going to explain that, but when you're incorporating a company, you can have your own articles if you want. Otherwise, you can simply adopt the model articles as your articles or the constitution of the company. Here, model articles. Now we are having what kind of a meeting? Shareholder meeting. Shareholder meeting. So let's look at under model articles, the article relevant to shareholder meetings. Let's see. Here you can find meeting of shareholders. Meeting of shareholders. Meeting of shareholders. Find out the word quorum. Here, method of holding meetings, and here you can see 8. There's a separate subheading for quorum. What does it say? Subject to paragraph 3 of this article, no business may be transacted at a meeting of shareholders if a quorum is not present. When you're conducting a meeting, a shareholder meeting, you can't commence or start the meeting if the quorum is not satisfied. If the article says you have to have a if the constitution says you have to have 3 shareholders to satisfy the quorum, if you have only 2, can you commence the meeting? No, you can't. Even though you commence the meeting, here it says, whatever the business you do, whatever the transactions that you make is invalid. Is invalid. The only thing, now here, the whole thing is important when you're answering this question. No business may be transacted at a meeting of shareholders if a quorum is not present. A quorum for a meeting of shareholders. So what is the quorum? Now it doesn't say 3 shareholders because it's the model articles which you have adopted. According to model articles, you will be able to satisfy the quorum requirement only if the shareholders or their proxies means I am a shareholder, I can't go for the meeting, I am busy, but I can send someone else on my behalf. On behalf of me, I can send someone else. That person doesn't have to be a shareholder. Since I am a shareholder, since I'm not in a position to participate in the meeting, I can send someone else. We call that person a proxy. So shareholders or proxies are present who were between them able to exercise majority of votes to be cast on the business to be transacted at a meeting. So you have to have basically that are present who are between them able to exercise a majority of the votes. If you can satisfy the simple majority more than 50%, then you can have the meeting. What if the quorum is not satisfied? You start the meeting. Let's assume you have scheduled the meeting at 9:30 a.m. In the morning, you have said, okay, we are starting the meeting at 9:30. But quorum is not satisfied as per subsection article 2 of article 8. Then you have to wait for 30 minutes, half an hour. You have to wait until 10 a.m. After that also, if the quorum is not satisfied, then can we conduct the meeting? No. No meeting can be conducted. The only thing that you can do is you can postpone the meeting, adjourn the meeting. To when? That is also given. Now assume this is a Tuesday 9:30. Wait until 10. Quorum is not present. Then you can't continue with the meeting. You have to postpone the meeting to when? That is also given. Next Tuesday, following Tuesday. If this is, let's say, 10th July, 17th July, next Tuesday, same time, same place. Same day, in the following week, at the same time and place. or such other date, time and place as the directors may appoint. If at the, so that is the meaning of quorum. So why it is so important? Because without satisfying the quorum requirement, you can't have a valid meeting, even though you continue, whatever the decisions that you make at that meeting are invalid, void. So that is the answer to that question. Here, based on the information, unlike the other ones that we discussed here, it's not straightforward. I can see Shinali, yes, has given an answer. Minimum number of shareholders that need to be attend at a shareholder meeting. That is partly correct. Not just shareholders, that shareholder should be able to exercise his voting power. Because there can be shareholders who doesn't have voting powers. So non-voting shares also can be there. Therefore, you have to be very specific. Even the examiner mentioned about this point, right? You have understood the concept, but when you're writing it, you have to be precise. So there you have to specifically say is the minimum number of shareholders who have the voting right. Not just shareholders who have the voting right. If they are present, then you satisfy the quorum requirement. Okay, right. Let's so since this is recorded and you can listen to it at a later stage, I'm not going to give you a break or anything. I will just continue. Okay, but this is the bulk. I mean, once you are done with these two questions, that's what I told you. You are done with 40% of the 40% of the paper. Yeah, so the query asks, the answer to that query is basically the first you have to explain what the quorum is. Some students, according to the examiner, has not explained what the quorum is. And some people have completely omitted to answer this question, avoided the question because they have not understood the concept of quorum. So quorum is a minimum number of voting members, not just members or not just shareholders, voting shareholders or voting members that must be present or in attendance at a meeting of a company for that meeting to be a valid meeting. Then you have to say, so first you explain what the quorum is. There, the key word is voting shareholders who have the ability to vote at that meeting. Then we know we have adopted the model articles. So then you can mention before that, first you explain what the quorum is, then you explain what is the consequence, the result if the quorum is not present. The result if the quorum is not present. If the quorum is not satisfied, that meeting is not valid. Whatever the decisions that you make, except for adjourning the meeting. Now, if the quorum is not satisfied, the only decision that you can make is postponing the meeting to the next week, the same time, same day. You can't transact, you cannot do any other transaction. You can only adjourn the meeting. If you make or if you do any other business, any other decision, if you make any other decision, they are invalid. The transactions or the decisions are void. What you should do is you have to adjourn the meeting. Then you explain 5 max allocated. So we will explain it further. Then you explain, since the company has adopted model articles, you explain this part. Here, too. You explain this part. A quorum for a meeting of shareholders is present as per the model articles if the shareholders or their proxies are present who are between them able to exercise majority of vote to be cast. You explain this. Then you explain the consequence. What if the quorum is not present? You cannot do any transaction. You can only adjourn the meeting after waiting for 30 minutes. So then you explain the third part. So basically, your answer is based on Article 8 of the model articles. First, you have to explain what the quorum is. What the quorum is. Right? And then you explain 1, 2, and 3 here. 1, 2, and 3. First, the meaning of the quorum. And then you say no business can be transacted at a meeting of shareholders if the quorum is not present. And then you explain, since the company has adopted model articles, how you can satisfy the quorum. For that, you have to have shareholders or their proxies who are present, between them able to exercise majority of votes. Then you explain if the quorum is not satisfied after 30 minutes, then it has to be adjourned to the next same day in the following week at the same time and place. So if you reproduce this, you can get full marks for this question. Right. Then finally, the solution proposed by Shane. What is that? Now, a director, a shareholder has a problem. Now, most of the shareholders are not coming for physical meetings, saying that transportation cost is high. So that means you can't have physical meetings. So the secretary is giving a solution. He says, company can follow the resolution in lieu of meeting. Resolution in lieu of meeting. Another term that we are using is by way of circulation. That means no physical meeting. What you do there? The resolution, you send it to all the shareholders of the company. If you have 100 shareholders, you circulate. You are not going to have a physical meeting. You circulate the resolution among all shareholders of the company. You give them a deadline and you ask them to vote, cast their vote, whether they are for the resolution or against the resolution, and send it back to the company on or before the deadline. Then after that, the company will count and see whether they are for the resolution or they are against the resolution, and accordingly, they will pass it. Now here, again, the answer is completely based on the Companies Act. Where can we find it? Can someone tell me the relevant section, please? Resolutions in lieu of meeting. Where can we find the relevant section? Let's see. Yes, section. Samir is correct. Yes, Ayub, section 144. Let's go there and see. 144. But you must know, I mean, when you go there, you even though you have not memorized it, still when you look at the section, you can figure it out. But these things, better to be familiar. Better to be familiar with the content, the characteristics, rather than, because this is a little complicated section, because students have made a lot of mistakes when it comes to this part, because they have not been able to correctly understand the characteristics or the features of this section. Not every company can adopt resolutions in lieu of meetings, because if the articles prohibit, if the constitution of the company, the articles of association of your company says, no, you can't have resolution in lieu of meeting, then you have to have a physical meeting. Here, that's why it says, subject to the provisions contained in the articles. If the articles of the company says you can't have resolutions by way of circulation or resolutions in lieu of meetings, then you can't do this. So if there's any restriction, prohibition stated in the articles, you can't do this. So that's one important thing that you have to mention. As per section 144, yes, a company can make resolutions without having a physical meeting. We call them circular resolution. However, if the articles of the company prohibit, you can't pass resolutions in lieu of me. But the question specifically says this company has adopted model articles. I'm not going to go through model articles here, but you go through it leisurely, you will see model articles do not restrict a company passing by passing resolutions in lieu of me. It doesn't restrict, it doesn't prohibit. Since this company has adopted model articles do not restrict a company by passing resolutions in lieu of meetings. Therefore, there is no prohibition. Hence, this particular company given in the question can pass resolutions in lieu of meeting, as it is permitted by, as it is not prohibited by the model articles, right? That is another thing that you have to mention in your answer. Then you have to explain how you can pass basically a resolution in lieu of meetings. Not, basically not the procedure. Yeah, kind of the procedure also, but the percentage. Now, normally if you take an ordinary resolution, you need simple majority, more than 50%. If it is a special resolution, 75%. But here, it's not more than 50%. It's not more than 75%. The examiner has said, some students have said 90%. But I don't know from where you get that, because the section clearly says you need what? 85%. So you can reproduce this part. So how you can pass a resolution in lieu of meeting? There shouldn't be any prohibition in the articles of association. Since we have adopted model articles, no such restriction. Therefore, we can pass the resolution in lieu of meeting. However, it should be signed by, resolution in writing should be signed by not less than 85% or more of the shareholders who would be entitled to vote. Again, it has to be a voting shareholder, not a non-voting one, on that resolution at a meeting of shareholder who together hold not less than 85% of the vote. So write down the whole thing, though you understand it or not. Right? So that is what you have to mention. And the other thing is, don't forget to mention this also. So 144 subsection 1, and then mention this also in your answer. Within 5 working days of resolution being passed under this section, the company shall send a copy of the resolution to every shareholder who did not sign the resolution. Because if you have 100 shareholders, you send the resolution to all 100. But assume only 80 people, sorry, let's say only 90 people responded. 10 people didn't sign the resolution, Then after passing the resolution, you have to inform those 10 shareholders who did not sign the resolution that, okay, resolution has now been passed. Within 5 working days of resolution being passed under this section, the company shall send a copy of the resolution to every shareholder who did not sign the resolution, because they should also know how the resolution has been passed, though they didn't sign. So that communication has to be done. So this is what you should include in your answer when answering part 4 of that question. Okay, right. It's very difficult to, there are a lot of things I could explain, but since we have limited time and it's only with regard to discussing of this paper, my hands are tight here, so I will not be able to explain each and everything, but feel free to. At the end of the session, I will share my contact number. So if you have any question, You can, I mean, I will share my email address. That would be easier. So there you can ask whatever the questions that you have if you need any clarification. All right. Okay. Right. So we have completed section. Now our life is easy. I took a lot of time, spent a lot of time, nearly 2 hours explaining the answers to the last two questions in section 2. But I have completed 40. At the exam, you can take only 72 minutes. But here, since I have to explain, I have taken more time. Now we will look at question number, section 2. There are 4 questions, but not stressful like this. Basically, straightforward answers we have to give. So now we will finish that part. Again, 40 marks, 72 minutes allocated. Your target should be to finish it within 1 hour. Then you have extra 1 hour to answer MCQs, right? So by pre-preparing yourself, pre-preparation extremely important. That's why it says pre-preparation prevents poor performance, right? So that's the key to get through any paper in your CA curriculum, right? Let's look at all questions are compulsory. Section 2 is 40 marks. Recommended time for the section is 70 minutes. Let's say. Explain the answer to the queries of Andy and Sandy. 4 marks. Always look at the way that they have allocated marks. Here 4 marks, here 6 marks. So they expect more to this one. But let's see what they have asked. Andy owns 30% of the shares in Dotwell Private Limited. As he is migrating to Canada, Andy wishes to transfer those shares to his friend Sandy. Right. 2 shareholders, Andy and Sandy. Andy has 30%. He's migrating to Canada. Therefore, he wants to transfer his 30% of his shares to Sandy. Both Andy and Sandy are Sri Lankan citizens. Andy has a few queries as follows. Whether the law permits such transfer, whether law permits such a transfer. Don't you have to give an answer here? But your examiner has said some people have not given, some students have not given correct answer, confident answer. You have to say either yes or no. But some students haven't done. That is because you're not sure about your answer. Whether the law permits such a transfer, yes or no. First, you have to give that. If so, what will happen to the rights attached to these shares upon such transfer? Examiner tells. You can go through it. Yeah, so student has given the answer saying yes. Yes, that's correct. But the examiner says some students have said no. Now that is wrong. Some students have said in private limited companies, you can't transfer. That is under the old act. Some students have said only in public limited companies can transfer shares freely. No, there's nothing such under the current Companies Act number 7 of 2007. Private or public shareholders have the freedom to transfer their shares to another shareholder, especially if they're Sri Lankan citizens. So the answer is yes. Give that first. If so, then you have another one. What will happen to the rights attached to these shares? Students have according to the examiner, some students have not answered this part. What happens to the rights attached to these shares? When you buy a share, as we learned earlier, the characteristics of ordinary shares and preference shares, I don't know whether you will be able to understand what I'm trying to say here. Even though you don't understand, it doesn't matter, just forget about it. Buying a share is buying a bundle of rights. Now, when you buy gold, you get something tangible. When you buy a land, you get something tangible. You can see the land, you see gold. You can touch it. But when you buy a share, do you see something tangible? Can you touch a share? Can you see a share? No, it is something intangible. Then why do we pay money to buy a share? Because when you buy a share, with that, you receive some rights. What kind of rights? Earlier we learned. We always assume ordinary shares. You get voting rights. The other main right is dividend rights. This is the main right that you get as an investor. So A was holding 30% in the company. If those shares are transferred to S, we say yes, he can freely transfer his 30% to Sandy. No restriction there, right? Then what happens? All the rights enjoyed by A will be transferred to Sandy. Basically, Sandy stepped into the shoes of Andy. What do you mean by that? Step into the shoes of Andy means whatever the rights enjoyed by Andy will now be enjoyed by Sandy once the transfer is done. Simple answer. But students have explained the procedure of transferring shares, method, you have to transfer the share certificates, you need the director's approval, unnecessary. They are asking a simple thing, whether the law permits such a transfer. Yes. If so, what will happen to the rights attached to these shares? All the rights previously enjoyed by ND will now be transferred to Shen. That means after the transfer, the dividend rights enjoyed by ND will be enjoyed by Sandy. Andy cannot enjoy those rights anymore. Now the shares are transferred to Sandy. The same rights enjoyed by Andy can now be enjoyed by Sandy. That is all you have to mention to get these 4 marks. But students have failed to do that also. Then the second part, Sandy also has queried as to whether separate management feature of an incorporated company. The examiner says the overall answer to this question is not satisfactory. Not satisfactory. Can someone tell me the answer to this part? What do you mean by separate management feature? Separate management. A lot of people have misunderstood this concept. That is why I'm asking this question from you guys. If someone can tell me, so then you will see whether you make mistakes or not. What do you mean by separate management? Yes, separate management. What does it mean? Right. A lot of students have thought this is separate legal personality. Yeah, now I can see a student has said owners of a company are separated from its management. Okay. Then directors are apart from shareholders. Yes, I can take these answers. But some students have said this is separate legal personality. Separate legal personality, which is not correct. If you take a company, always remember this. Who are the owners of the company? Shareholders. Owners. Then management is done by who? The board of directors. They are responsible for the management. Always remember this. This structure, very useful. Separate legal personalities, some other concept. That is, shareholders and the company are different. They are not asking about that. They are asking, what is this separate management? Separate management. Separate management means the ownership and the management of the company are done by two separate parties. Now, if you take a partnership, partners manage the business. They are the owners, they are the managers. But in a company, we see a clear distinction between the ownership and the management. You call it stewardship also, stewardship. Think of a country. Now, who owns this country according to the constitution? People of this country. We have 22 million of the population is 22 million. According to the constitution, we people own the country to 22 million. But can all of us control or manage the country? No. That is why we have appointed a president. We have appointed 225 parliamentarians to manage the country. Likewise, in a company, similarly, in a company, the owners are the shareholders. Let's assume there are 1,000 shareholders. But all these shareholders cannot get involved in management. Therefore, they appoint a separate group of people to manage the company. We call them directors. Let's assume we have appointed 5 people. Some directors can be shareholders of the company, but it's not necessary. Unless the articles want you to be a shareholder to be a director, otherwise it's not necessary. Otherwise, it's not. Even most of the companies, even one shareholder, you can become a director. So some shareholders will get involved in the management. That is possible. But if you're only a shareholder, can you get involved in the management? No, you can't. If you're merely a shareholder, remember, you are not permitted to get involved in the management of the company. There is this case, you don't have to mention, Royal British Bank case, Turquand versus Royal British Bank. We call it the Turquand rule. We call it the Turquand rule. That's not relevant to this question. I mean, you don't have to mention that in the answer. But for your additional information, I'm just giving you that. Accordingly, the ownership and the management ownership is different or is separated from the management. I'll give you a simple example. All of us can buy shares through the stock exchange. Let's assume you buy 10 shares in commercial bank. Now you are a shareholder of the bank. Next day, can you go to a branch or can you go to the head office of commercial bank and say, here, now I am a shareholder of this company. I'm the owner of this bank. I'm one of the owners of the bank. I'm a shareholder. Therefore, you have to manage the company, manage the bank according to my instructions because I'm an owner. Can you do that? Obviously, you can't. They will think that you're crazy and they will send you to the lunatic asylum. Right? So you can't. In a company, even if you're merely a shareholder, you can't get involved in the management. The only way that you can intervene or get involved in the management is at the shareholders meetings. You can vote and pass resolutions. By passing resolutions, you can basically interfere with the management. That's the only way. Otherwise, you cannot get involved in the management of the company if you are merely a shareholder. That concept we call separate management. Shareholders and the board of directors are basically different from each other. The shareholders are the owners. The board of directors are responsible for the management. If you're merely a shareholder, you cannot get involved in the management of the company unless at a shareholders meeting. So this is what you have to basically mention in your answer to score this 6 marks. So first you say the shareholders are the owners and the administration or the management of the company are vested with the directors. And you can say the directors are appointed by the shareholders to manage the company. There are 1,000 shareholders. Among them, you can appoint 5 people. If you want, you can appoint more to manage the company. So the shareholders can appoint the board of directors. It's like We appoint the president, we appoint the prime minister and the parliamentarians. The shareholders appoint the directors to manage the business. Shareholders need not be directors of the company. Now here, out of 1,000, 5 have become directors, balance 995 are merely shareholders. Unless you are a director, you cannot take part in the management of the company. The only way that you can interfere with the management is by way of resolutions passed at a shareholder meeting. Otherwise, you cannot get involved in the management of the company. This is known as separate management. Separate management. So don't confuse yourself with separate legal personality. So that is the answer to this question. So that is done. 10 marks. Within 18 minutes, you should be able to answer this question. Target 15 minutes. I don't think even it will take 15 minutes if you know the concept properly. Then question number 3. Frederick is a minority shareholder of Cocoche Private Limited. He has the following queries. Minority shareholder. Is there a rule to say that any decision regarding the company should be made with the consent of the majority of shareholders? Is there a rule? Rule. This has been asked in each and every paper that I have discussed so far. Every paper, you get this. The rule to say that any decision regarding the company should be made with the consent of the majority of shareholders. Can someone tell me the rule? Because there's a question. You have to give a straightforward answer and then explain. Are the decisions so made binding on the minority shareholders who do not agree with such decision? You have to give a straightforward answer to this. Whether the minority shareholders are bound by the decisions made by the majority shareholders. Peter, another minority shareholder, has told F that the Companies Act number 7 of 2000 provides safeguards in relation to minority shareholders of a company. This is what we call the protection available to a minority shareholder. I will explain it in this way, see whether you understand. Now, it's like this. Now, even in a country, you get the majority. Then you get the minority based on the race, based on the religion. We say we are the majority, we are the minority. Here in this country, we say Sinhalese are the majority. Then the others are the minority. Now, we say we should not discriminate the minority. We have to look after the minority in a country. But in a company, it's slightly different. Okay. That is because a company is incorporated to generate what? Profits. To generate profits. Generate profits. Okay. Let's assume this company has 5 shareholders, A, B, C, D, and E. Right? A has, let's assume A has bought 1,000 shares. B has bought 2,000 shares. C has bought 3,000 shares. I'll have 3 shareholders. That's enough. Then the value of a share, let's assume 10 rupees. That means he has invested 10,000 rupees. B has invested 20,000 rupees. C has invested 30,000 rupees. Now tell me, in this instance, who has invested more? C. Whose risk is higher? If I have invested more, my risk is high compared to the other shareholders who have invested a lesser sum. I have invested 30,000, therefore my risk is high. If something happens to the company, that means if something happens to the company, who will have the greater impact? Who will have the greater impact if something adverse, or I'll put it this way, if the company incurs a loss, who will have to suffer more? It is C, because he has invested more. Then the company law says, you have invested more, therefore, we will give you more powers when you're making decisions on behalf of the company. Because you have invested more money, therefore your risk is high. If something goes wrong in the company, you're the person who's going to get affected the most. Therefore, we give you more powers. How do we get more powers? These are shareholders. I told you earlier, if you have one share, you get one vote. If you have 1,000 shares, you get 1,000 votes. So he has 1,000 votes, B has 2,000 votes, and C has more votes, 3,000 votes. Therefore, when you're passing resolution, C can influence more in this decision-making process. It's reasonable. No one can say it's unreasonable. I mean, no one can say it's unreasonable because he has invested more, his risk is high, therefore, he has more voting powers. This is what we call the majority rule. This is a common question at the exam. You always get it. So make sure you go through it carefully. Question A, explain F's queries with reference to the name of a decided case. The moment you say the majority rule, the moment you refer to the phrase majority rule, straight away, it should come to your mind. It should come to your mind. What is that? This particular case should come to your mind. What is that case? The majority rule always goes with this famous case in the United Kingdom. What is that? I can see a student giving me the answer. Yes, Samira, you are right. Foss versus Harbottle. Foss rule. We call it Foss rule. Now here, no required to mention facts and decision of the case. Even though they have mentioned this in plain language, don't explain the facts and the decision. Some students have still explained the facts and decision. Just work according to the instructions given. You save time, you score marks. That's the golden rule here. They are asking you to mention the name of the decided case only. It is Foss versus Harbottle. It is Foss versus Harbottle. So you mention the name of the case, Foss versus Harbottle, but they have allocated 6 marks. Therefore, you explain the rule. They're asking, what is the rule here? What is the rule? Is there a rule to say that any decision regarding the company should be made with the consent of the majority shareholders? Answer is yes. You call it the majority rule. Call it the majority rule. And this was first laid down in the case Foss versus Harbottle long time back in 1800s. In 1800s. According to that judgment, you don't have to explain the judgment, but the majority rule says, now, when you're passing a resolution, you have 100 shareholders who have 100 shareholders, and out of them, let's say 80% says we should pass this resolution. We call it for the resolution. And 20% says, no, we are against the resolution. The resolution is passed. Resolution means the decision is made. Why? 80% of the shareholders who have 80% of the voting rights, they say, no, we are for the resolution. we should make this decision. But 20% says, no, we should not. Then you get the answer to the second question. If 80% says, yes, we should make this decision, then the company must implement that decision. We call it the majority rule. We ignore this minority who have voted against the decision. Then can the minority says here, even though you agree, we are not bound by this decision. You guys have consented, but we have not consented. Therefore, we are not bound. Can you say that? No, you can't. If the majority has made a decision, minority is bound by that decision. That's the answer to the next part of the question. Are the decisions so made binding on the minority shareholders who do not agree with such decision? Again, yes. The minority shareholders are bound by the decision made by the majority. They are bound by the decision. Even though they have voted against that decision. We call it the majority rule. We call it the majority rule. So in a company, your powers as a shareholder depends on what? How much? How many shares you have? If you have 1,000 shares, you have 1,000 votes. If you have 100,000 shares, you have 100,000 votes. So their ability to influence decision making is more because you have 100,000 shares. In other words, you have invested more. Therefore, you can influence the decision making. You call it the majority rule. I have only 1,000 shares. I have voted against the decision of the company, but still, I cannot say I'm not bound by that decision because I am bound by the decision made by the majority. Then a question arises. So these 20% shareholders do not agree with the decision. Is there any protection given to those shareholders? That's the answer to the next question. State 4 protections or 4 safeguards that P, another minority shareholder. What is his query? I'm a minority shareholder. Is there any protection in relation to the minority shareholders of the company? Yes. 4. State 4. Do you have to explain them? Do you have to elaborate them? No. 1, 2, 3, and 4. That is all you have to mention. Do you need now here 4 marks? That means basically 7.2 minutes. Do you need 7.2 minutes to write 4 answers? Of course not. What are the protections available to a minority shareholder under the Companies Act? These things you should remember. One is minority buyout. Minority buyout. This is first introduced under number 7 of 2007 Companies Act. If you look at section 93 onwards, you have the minority buyout. Best example is this. Now, 80% have said we should proceed with the decision. 20% they say, no, we can't. But you are bound. However, you don't want to continue. You are not agreeable with the 80%. Then either you have to continue, either you have to agree with the 80% majority, or else you should leave the company. Here, that means you should exit the company. So if you can't be with the majority, you can't do anything. Either you comply with the majority or you should leave the place. You should leave the company. For you to leave the company, there is a special protection given. You call it minority buyout. You can say here, I'm not agreeable to the decision. I went against the decision. I voted against the decision. Therefore, please buy my shares and give my money back. That is what we call minority buyout. Please look at section 93 onwards, minority buyout. Please buy in simple terms, it means take my shares and give my money back. I want to leave the company because I don't want to be bound by that decision. So we call it minority buyout. Then very important protection provided to minority shareholders under section 224 and 225. You don't have to mention the sections, but good to be familiar with the sections. You call it oppression and mismanagement. Minority buyout, oppression and mismanagement. Then section 233. What is that? If there is anything happening which you don't like, and if you feel that the directors act according to the articles of association, they are violating the constitution of the company, then under section 233, you can obtain a restraining order. Restraining order. Memorize this, restraining order. That means they are going to do something. Before doing it, you go to court and obtain an order to prevent the company by making that decision. You call it a restraining order. The other one is you call it 234 onwards, derivative action. You bring an action on behalf of the company, but you don't have to explain anything. You just have to remember the protection available to a minority shareholder. One is minority buyout, section 93 onwards. Then section 224-25 explains oppression and mismanagement. You can take as one. Then under section 233, you can obtain a restraining order. Fourth, derivative action under section 234. That is, you bring an action on behalf of the company. It's not the time for me to explain these things in detail. Anyway, you don't have to explain it in detail here. You just list down them and you get 4 marks, right? Then let's move to the next one. Yeah, just one question here, no sub-questions. With reference to a decided case, whether it is lawful for MG to accept these additional functions in her capacity of a company secretary. So this question is about company secretary. Again, the examiner says that the students have not answered in a satisfactory manner. Most of the students have made a lot of mistakes when answering this question. Right? So let's see what we are supposed to do here. Okay? Right. Manik Gomez, MG, is the company secretary of Yankee Private Limited, YPL. Since joining the company in 2018, she has been carrying her duties according to the law. Recently, some directors and some key staff members vacated office due to overseas migration. And therefore, MG was told to undertake the following additional activities. There are 3. So MG is the company secretary. So you have to ask yourself, can the company secretary perform these acts? Employing new staff to YPL, recruiting new people to the company. Second one, getting involved in the day-to-day administrative management of YPL, administrative. Third one, filling in the vacancies in the director board of YPL. To answer this question, you should know the powers of a company secretary. Company secretary. Here, 10 marks allocated. So you have to give a substantial material answer. Explain with reference to a decided case. When it comes to a company secretary, like the majority rule, you have to always refer to Foss versus Harbottle. Always remember, if the question refers to the powers of a company secretary, there is this particular case that you should always remember. What you can do is go to the relevant section in the Companies Act with regard to company secretaries. There, you write down this case. You can even write down the facts and the decision, which will be useful when you're writing an answer to a question like this. So you don't have to memorize it. What is the case? The case is Panorama Development Guilford Limited, Panorama Developments Guilford Limited versus Fidley's Furnishing Fabrics Limited. Here you have to explain the facts and the outcome of this case. So you have to, if you can't memorize it, go to the relevant section in the Companies Act and write down this section. Panorama Development Guilford Limited versus Fidley's Furnishing Fabrics Limited. Now here, what happened in this case? Here, the company secretary was, I mean, the name was Brian, but the company secretary, what he did was, Brian was the company secretary of Fidley's Furnishing Fabrics Limited. Fidley's Furnishing Fabrics Limited, he was the company secretary. Then what he did was, during the absence of the managing director of the company, he ordered some luxury vehicles. He rented out some luxury vehicles from Panorama Developments Guilford Limited. Panorama Guilford Limited. So, okay, Panorama P. Fidley's is the company. Questionable companies, Fidley's. And Brian B. He was the company secretary. What he did was saying that he's doing it on behalf of the company. He rented out some luxury vehicles such as Jaguars, Rolls-Royce, that kind of vehicles he rented. He said, I'm doing it for the company. But he actually did it for his personal benefit. He personally received the benefit. He, in fact, didn't do it for the company. It was, those vehicles were not rented on behalf of the company. No. He did it for his personal benefit. Fidley's Furnishing Limited, the company got to know about it and they sacked him. And ultimately, actually, he went to, there was he committed a criminal offense. Therefore, he was convicted, criminally convicted. But that is not the relevant part here. Then Fidley's refused to pay that rent to Panorama Company. Panorama Company said, here, he is your secretary. He said he's doing it for your company. Therefore, you have to make the payment. Fidley's Furnishing Company Limited said, no. We didn't ask him to rent out vehicles. We have not given him the authority to do that. Therefore, you get that money from him. We are not going to pay that. But Panorama Limited argued, no, he's your company secretary. He has the authority to do this on behalf of the company. Company cannot say at a later stage, here, we are not bound by this decision. Because he's a higher officer of the company, like a director. Now, if a director has rented out, you have to still make the payment. You cannot say here, we didn't know and we have not given permission. The director always have the expressed, and you call it ostensible authority. That's the word you have to use. It is not expressly mentioned. But now, some powers are expressly given. Article says you can do this. The constitution of the company says you can do this. Or the Companies Act specifically says the directors or the company secretary have these powers. Even though it's not expressly stated, remember, because of the position that you're holding as a director or as the secretary, there are certain powers that you have automatically because of the position. If you are a director, you can do a lot of things even though it's not expressly mentioned. You can represent the company. You can bind the company by making certain decisions. Likewise, the company secretary also can do that. Therefore, Panorama Company said, he's your company secretary. We genuinely believe that he's doing it for the company. Anyway, he has the authority to do that. Fidley said, no, we have not given him authority. Panorama said, I'm not referring to express authority. Because of the position that he's holding as the company secretary, automatically he has received this authority. We call it ostensible authority. Ostensible authority. Implied, it's kind of an implied authority, not expressed, but because of the position that he's holding, he has this authority. Lord Denning, in this delivering the judgment, Lord Denning delivering the judgment here said here, delivering the judgment said, a company secretary is not a clerk. He's not a peon of the company. Like a director, he also can sign contracts on behalf of the company. When you're entering into, when you're buying a land, when you're selling a land, if a director is not there, the company secretary can sign. So he is a superior officer of the company. Therefore, a company secretary has administrative powers, is not a mere peon or clerical officer of the company. He's holding a higher position, has the ostensible authority, such as renting vehicles on behalf of the company. Though he has done it for his personal benefit, the company cannot say to the person who provided the service, he cannot do that, and we have not given him the authority because he has the ostensible authority to do that. Company can recover it from the company secretary, but they cannot tell the people who provided the service, we can't make the payment. Then otherwise, what will happen? They will ask the director to enter into the contract, and later they can say here, we are not responsible. You ask the director or you ask the secretary. You can't escape from that obligation because the directors and the secretaries, they have the ostensible authority. So Lord Denning delivering the judgment herald is not a mere, peon or clerical officer of the company. He's holding a higher position. Therefore, he has the authority to enter into this contract. Hence, he has acted as an agent of the company. Agent of the company. Therefore, the company is responsible to make the payment. So prior to this judgment, actually, company secretary was considered as a clerical staff member, didn't have any powers. So Lord Denning in his judgment specifically said he's not a mere clerk. In verbatim, if I use the exact words, Lord Denning said he is no longer a mere clerk. He's an administrative officer. So he has the administrative powers such as recruiting employees, recovering debts on behalf of the company, and any other administrative. But he cannot make financial decisions. He's an administrative officer, but like borrowing money from a bank, that kind of things he can't. Administrative powers are there. Please do remember because it's commonly tested. Now we have been given three options. Basically three situations. Can this company secretary employ new staff? Yes, he can, because he has the ostensible authority to do that. Getting involved in day-to-day administrative, yes, of course, that's why I told you he's an administrative officer, he can do that. Filling in the vacancies in the director board, can he do that? That he cannot. Why? According to the Companies Act, who can appoint the directors? Appointment of directors. Look at the section. Appointment of directors can only be done by the shareholders of the company. So it is expressly stated in the Companies Act that power of appointing directors is only with the shareholders of the company. Company secretary has not been given that power. The Companies Act is very clear. It has given that power expressly to the shareholders of the company, that is to appoint directors. The secretary does not have either express or ostensible authority to appoint directors. So you have to, one by one, you have to explain that. Employing staff, possible. Getting involved in day-to-day management, possible. but he cannot filling filling the vacancies in the director board of the company, because that power, if you look at section 204 and 5 of the Companies Act, to be precise, it is with the shareholders of the company. So the company secretary cannot do that. And the examiner has specifically mentioned in this, you don't have to refer to the sections. You just have to explain the outcome and the role of the company secretary. In particular, panorama case, please do remember, you don't have to memorize it, but write down the facts and the judgment near the relevant section in the Companies Act about the company secretaries. So you can reproduce the same thing at the exam. So panorama judgment specifically says the company secretary is not a clerk, a mere clerk anymore. He has the administrative powers, right? Okay, so that's the answer to that question. Then the next question. Basically, the last question under section 2. Last question under section 2. State the documents that CC must deliver. Okay, we'll read the question from the beginning. Channel Private Limited, that is CC, an overseas company wishes to register and establish a place of business within Sri Lanka, in accordance with the provisions of the Companies Act number 7 of 2000. Okay, right. Once the registration is complete, CC as a permitted investor under the Foreign Exchange Act number 12 of 2017 intends to purchase foreign currency from a licensed commercial bank in Sri Lanka in order to make payments to persons resident outside Sri Lanka and outward investment payments. That means sending money out, investing out of the country. So it's about an overseas company wishes to register and establish a place of business within Sri Lanka. Once the registration is complete, CC as a permitted investor, they want to buy foreign currency. It's permitted under the Foreign Exchange Act number 12 of 2017. In order to make payments to persons outside, resident outside Sri Lanka as outward investment. Okay, right. Now, A, state the documents that CC must deliver to the Registrar of Companies for registration purposes and the time frame within which these documents must be so delivered. Again, the examiner is saying, though the question is straightforward, students have unnecessarily wasted time explaining the whole registration procedure. And they have even got the time frame wrong. Some people have said within 1 year, something like that. But if you identify the relevant section, you can just reproduce the section. It's very clear and straightforward, and easily you can score 6 marks. So this is about registration of an overseas company. Again, a common question. I have discussed this again and again. I think all the other papers also. I think YouTube channel is their official YouTube channel of the Chartered Institute. They have uploaded all the previous paper discussions also. Then you will see, please go through them as well. You will see most of these questions are kind of repetitive. So if you do few past papers, then you will realize again and again you get the same question. But I must tell you, this paper, some questions are a little different, but if you look at most of the past papers, 50 to 60% at least repetitive. Therefore, if you answer past paper questions, you will be able to figure out the highly examinable areas very easily. Anyway, let's see. The relevant section here, it's about overseas companies. Registers and registration of documents. Okay. Part 18. You can highlight this part now itself. It's a highly examinable area. Overseas companies. And it explains what an overseas company is. Overseas company means by a company or body incorporated outside Sri Lanka. Incorporated outside Sri Lanka, already incorporated, let's say in the UK, which after the appointed date establish a place of business within Sri Lanka. You incorporated outside Sri Lanka, then you have a place of business in Sri Lanka also, then you can register it as a overseas company. Most of the branches, like most of the banks, Deutsche Bank, Citibank, they are considered as overseas companies anyway. This is the answer. Documents and particulars to be delivered to the registrar by overseas company. That's the question. And within how long? And what's the time duration for you to submit? 6 months. Every company incorporated outside Sri Lanka, which after the appointed days establish a place of business, shall within, the time period is given here, within 1 month. 1 month from when? From the date of establishment of its place of business, delivered to the registrar for the purpose of registration. You have incorporated outside Sri Lanka. Now you have started a place of business within Sri Lanka. And after starting, within a period of 1 month, you must deliver the registrar of companies these documents. So you can just reproduce a certified copy of the charter, statutes, or memorandum and articles of the company or other instruments constituting or defining the constitution of the company. So that is enough. So number 1. Then list of directors of the company containing such particulars. That is number 2, right? With respect to the directors as are by the act required. And then the names and addresses of one or more persons resident in Sri Lanka authorized to accept. Now here they have not mentioned how many points. So write as much as you can. So this is the first one. This is the second one. This is the third one. Names and addresses of one or more persons resident in Sri Lanka are authorized to accept on behalf of the company. Service of documents or any of notices required. Even though you don't understand, it doesn't matter. You just have to explain them. I mean, you just have to write them. You don't have to explain anything. All right. Okay, so that's the third one. Then you have several other statement containing the full address of the registered or principal address of the company and the principal place of business of the company. And certified copy or certified of recent date of any document effecting or evidencing the incorporation of the company. So you can mention these 5 requirements. Apart from that, you have to say that after setting up the place of business within 1 month, you have to submit these documents to the registrar of companies in order to register your business as a overseas company. So that is basically the answer to part A. So it's not anywhere else. It's in the Companies Act itself. So it's just a matter of identifying the relevant section. All right. Then state 4 capital transactions are. This is not from the Companies Act. This is not from the Companies Act. This is where you have to spend more time because more time memorizing certain things. Now I have the CL4 textbook. CL4 textbook. Now look at the chapters here. Look at the chapters. I mentioned this at the beginning. I believe that this will be useful for you guys when you're doing this, when you're preparing yourself for the exam. Now, these are the topics. Features of a company and corporate personality. It's from the Companies Act. Incorporation of the Companies Act. Equity and debt capital, Companies Act. Directors, company secretary, and Auditors Companies Act. Meeting resolutions and company records, Companies Act. Winding up, Companies Act. Minority rights, Companies Act. Actually, companies limited by guarantee and overseas companies, Companies Act. So 80% of the syllabus based on the Companies Act, and that is a book that you can carry. That is a statute, a material that you can carry with you to the examination hall. Therefore, your requirement to memorize will be limited. So you don't have to waste your time memorizing. Instead, when you're going through these topics, first 1 to 8, write down short notes in the Companies Act in the near the relevant section of the Companies Act. You don't have to memorize it. But these two topics, listing of company in the Colombo Stock Exchange and other laws adjacent to corporate law, they are not part of the Companies Act. Therefore, this 20% is important. When you're spending or when you're allocating your time, I would suggest you to memorize these two topics. Allocate more time, memorize these things. You can get a very good grade. I assure you, you can get a very good grade if you can excel in these two topics also, because even the examiner has mentioned when it comes to these two topics, most of the time students don't write proper answers. That is because these two are not there in the Companies Act. These two you have to memorize. So allocate more time when you're studying these two chapters compared to the other ones. Others are important, but you can always write the notes in the Companies Act itself. These two you can't do. Therefore, please do remember this as well. Right. Then, this question is not from the Companies Act. Is not from the Companies Act, right? It's from Exchange Control Regulations. Capital transaction that sees is permitted to enter into and make outward investment payments for capital transactions. What are the capital transactions that you can make? So if you have memorized, then easy 4 marks that you can get here. Now, one is, so here, this company is an overseas company. It is permitted by the Foreign Exchange Act number 12 of 2017 to purchase foreign currency from any licensed commercial bank in Sri Lanka as an authorized dealer. Only an authorized dealer, such as a commercial bank, can issue foreign currency. Not every bank or every person can issue foreign currency. So he's an authorized dealer under the Exchange Control Act, Exchange Act, Foreign Exchange Act. So they can issue foreign currency to this company to make payments resident outside Sri Lanka. Your examiner has said, some students have explained about inward payments. The question specifically says, what are the outward payments that you can make? Why do you have to write inward investment payments? So those are, cannot be justified. Extremely negligent on your point, on your part, which you should make actually. So it's outward investment payments. So what are the outward investment payments? There are several, but they have asked only 4. What are they? To acquire. Not just, sometimes students say purchase. No, to acquire and hold. To acquire and hold. That's why you are required to memorize this. Best thing is to memorize. Acquire and hold shares and debt securities, such as debentures, of companies incorporated outside Sri Lanka. But when you say purchase shares, that's incomplete. Some students have made such mistakes. Here you have to specifically state, since it's an outward investment, it has to be shares or debt securities incorporated outside Sri Lanka. In other words, overseas companies. That is one. Acquire, then hold shares or debt securities of companies incorporated outside Sri Lanka, in other words, overseas companies. Then to acquire and hold, you have heard about unit trust. So you can buy units in unit trust and mutual funds. These are, financial terms actually, more than legal terms. These are financial terms. So even though you're not familiar with it right now, doesn't matter, memorize it. Then to acquire, so unit trust, units in unit trust and mutual trust. Then the third one, other governments like Sri Lankan government, we issue sovereign bonds. Likewise, overseas governments, maybe in Greece, UK, Germany. So those governments also issue securities, government, we call them sovereign bonds. So to acquire and hold sovereign bonds issued by foreign governments. But there's a restriction. You can invest in government bonds issued by a foreign government. However, the rate or the interest or the discount offered by the foreign government should be similar or above the sovereign credit rating of Sri Lanka. So those government bonds are rated. So you can investment in sovereign bonds issued by foreign governments, but the credit rating of those government bonds should be above, at the rate or above the sovereign credit rating given by Sri Lankan government at the time of investment. So that is the third bar. Apart from that, you can go and start a branch, a liaison office, a marketing agency. You call it permanent establishment for tax purposes, would have learned it. P is permanent establishments. So you can go and start a branch, liaison office, marketing agency. You can do a project, some kind of a similar office, overseas office in a foreign country. So for that, such purposes, you can remit money outside Sri Lanka. You call it outward investment payments. Best thing is to memorize that, right? So with that, we conclude section 2. So I had to go a little fast, but I still took nearly 1 hour to discuss. But what I can say, you're not going to get the same question, but sometimes most of the questions can be repetitive. I can only explain the methodology, the approach that you have to take. So please go through this recording once again and see whether you can get something out of this and use them in your exams as well. So I'm actually sharing my experience also. I've been a lecturer in ACC for a very long period of time. And I myself have done a lot of exams, law exams, ACC exams. So all those exams. So with that, I'm telling you the different approaches, the approach that I took. So I believe that you can learn something out of it. So now we will look at section 1, where you get the it's like having a dessert. The main meal is over now. Now the dessert, you're done with section 1 to section 2 and 3. The difficult part is over now. So you can, leisurely. Now you have come to the end of the paper now. So you have covered 80% of the paper. Now you are left with 20%. Now you can leisurely answer those 10 questions where you have been allocated 20 marks. The good thing is you have 4 answers for each question. Therefore, there's a 25% possibility of getting the correct answer, even though you're not sure about the answer. You can increase that percentage also by excluding the wrong answers. I'll come to that in a while. So I believe, this is my personal view, you can have your own approach. No harm if you're comfortable with it. What matters is whether you're confident or not. So my view is, personally, I would love to answer these 10 questions towards the end, because now I don't have to rush much. I have completed 2 hours, let's say 2 and 15 hours, 2 hours and 15 minutes. Now I can answer the MCQs, right? Because I have 4 answers also given. Right. Now, first question. So for this part, I can spend 36 minutes. So if I have 45 minutes, more than enough. The first one, right? The following statements. So sometimes this can be tricky, but you can look at the Companies Act also when you're answering questions like this. Some are not in the Companies Act anyway. Let's see. Always read this part first here. Which of the above statements are correct? Correct. Sometimes they can ask the statements which are incorrect. Therefore, start with this. Above statements are correct, right? The following statements are about listed entities and the boards. You have this divisory board, you have the main board, then you have the Empower board, then you have multi-currency board, likewise different types of boards. That's why I told you, they're not in the Companies Act, chapter 9, chapter 10 of your textbook, memorize them, right? Finish those 2 chapters early and prepare notes and memorize them. That will reduce your burden, right? Boards that can be listed on the Colombo Stock Exchange. Okay, first one. A listed entity security may be listed on either the main board or divisory board of the Colombo Stock Exchange. Is it correct? Yes, it is correct. It is correct, right? Then listed entities that have a higher capital base are listed on the main board. That is correct. Where startup businesses, mid-sized businesses, and small businesses are listed on the divisory board. That is also correct. The Empower board that was launched in 2018 is intended for the top 100 entities capital base wise. No, that is not correct. That is not correct. Then a foreign entity that wishes to list on Colombo Stock Exchange. They started mainly for this purpose, that is to encourage foreign entities to list their companies on the Colombo Stock Exchange. That is multi-currency board. So these are accurate answers. 1, Roman 2, and Roman 4. 1, Roman 2, Roman 4. So the answer is C. So C is the correct answer here. Right. Then, which of the following statements is correct in relation to pre-incorporation contracts? What is a pre-incorporation contract? When you are incorporating a company, you have to make certain arrangements to incorporate the company. Now, you are going to start a new company. You have to prepare articles of association. If you don't know how to do that, you have to go to a chartered accountant or as a lawyer doing the job of a company secretary and tell them, here, we want to incorporate a company. Please do the needful. Please prepare articles of association. Please submit the relevant documentation to the registrar of companies and get us the certificate of incorporation. Please open up bank account. Please get us tax identification certificates, TIN number, and that kind of work. Now, all those things you try to do before starting the company. Sometimes you will have to rent a premises. Before incorporating the company, you have to find a place to start the business. You may have to enter into contracts with the suppliers, customers. You will have to enter into a lease agreement with the building owner. So all those things you have to do before starting the company, before incorporating the company. So those transactions, those contracts that you enter into before incorporating the company, we call them pre-incorporation contracts. This law, the law pertaining to pre-incorporation contracts in Sri Lanka under the Companies Act are significantly different from the Companies Act in the UK, but you don't have to think too much about that. We should only be familiar with the pre-incorporation contracts in Sri Lanka. If you look at the study text, pages 34 and 35 of your study text, you can find the relevant note on pre-incorporation contracts. Accordingly, by the way, for the previous question about the stock exchange, please look at page number 159 of the textbook for more details. Right. Anyway, we have to find out which statement or statements are correct in relation to pre-incorporation contract. It is a contract entered into for and on behalf of the shareholder of a proposed company prior to its incorporation by its promoter. It is a contract entered into for and on behalf of the shareholder. Is that correct? No. These are contracts entered on behalf of a company, proposed company, not on behalf of the shareholder of a proposed company. It's on behalf of the proposed company prior to its incorporation. Therefore, A is not correct. The ruling in Kellner versus Baxter prevents the recognition of pre-incorporated contracts by law. Now, Kellner versus Baxter, I must tell you, that's a UK judgment. And as I told you, has no relevance to the pre-incorporation contracts law in Sri Lanka, because according to UK law, pre-incorporation contracts cannot be ratified. Now, here they say prevents the recognition of pre-incorporation contract. That is also not correct, but only thing they cannot be ratified. You can proceed with. But in Sri Lanka, pre-incorporation contracts must be ratified, because when it comes to pre-incorporation contracts, there's a difficulty. There's a legal issue. What is that? Company is not incorporated. That means there is no legal person, but you're doing it on behalf of the company. But the company is not there yet. Then a question arises, can the company be bound by that contract because the company was not incorporated at that time? The company was not in existence at that time. It's like you enter into a contract on behalf of an unborn baby. Baby is not born yet. You enter into a contract on behalf of the unborn baby. UK law says that's not valid. The unborn baby, when it's born, can't say, I'm okay with the contract in the UK. But in Sri Lanka, it doesn't matter. The Companies Act specifically says once the company is incorporated, the company has to accept the contract. Therefore, B is also not correct here. These are contracts by which the promoters obtain properties or secure other rights and obligations as a prerequisite to the incorporation of the company. Absolutely right. That's why I told you. You go to a company secretary and say here, please incorporate the company. Please prepare the articles, prerequisites. Get us back, open up, basically, we want to enter into a lease agreement. So that kind of conduct, prerequisites, enter into contract with suppliers, customers. And anyway, let's look at D also. The Companies Act number 7, 2007 doesn't recognize pre-incorporation contracts and they have no effect legally. Absolutely false. It's the other way around. It has effect in law. So D is also wrong. C is the correct answer here. Then let's look at the next question. The Companies Act number 7 of 2007 provides for companies limited by guarantee. There is a separate chapter. So if you look at section 32, 33, 34, 35, that those sections you will be able to see companies limited by guarantee in the textbook. Look at page number 141. Which of the following statements is correct in relation to such companies limited by guarantee? These are basically non-profit making business organization. And there you don't have shareholders, you have members. And they cannot distribute profits among the members, no dividend, because there are no shareholders. Their liability is limited to an amount agreed at the time of incorporation. It can be 10 rupees, it can be 100 rupees. So at the time of winding up, if the company has no assets to settle all the liabilities, then every member has to contribute that amount to settle the liabilities. Can be any amount that they have agreed at the time of incorporation. And if they want, they can avoid the use of the word limited, because these are non-profit making business organizations. So moment you use the word limited, it gives you the impression that it's a profit making organization. So to give that opportunity, they can obtain permission from the Registrar of Companies to use the name of the company without using the word limited. So those are the main features of a company limited by guarantee. So what is the correct statement? They can issue shares. I told you, there are no shareholders. They can't issue shares. So first one is wrong. Its members must contribute to its assets and amount specified in the articles if the company goes into liquidation. Yes, that's a correct answer actually. So this is why we call it limited by guarantee. At the time of incorporation, they give a guarantee saying, at the time of liquidation, if the company has no resources or assets to settle the liabilities, we will contribute this particular amount, a fixed amount. We call it limited by guarantee. The law doesn't permit such a company to be registered without the word limited. No, that's not correct. I told you, they can register the company without the word limit, the opposite. Its members are entitled to receive dividends. I told you, there are no shareholders. It's prohibited. It is prohibited for a company limited by guarantee to distribute their funds, their profits among the shareholder, among the members as dividend or in any other means. You can't. Therefore, it is wrong. So the answer is B. The correct answer is B. The next one. Which of the above statements are correct in relation to the functions of the Department of Foreign Exchange of the Central Bank of Sri Lanka, CBSL? Again, something you need to memorize because it's not in the Companies Act. It's not in the Companies Act, therefore, something that you have to memorize the functions. But sometimes even if you use little bit of common sense, you might be able to get the answer, the correct answer, right? Let's see. Ensuring the smooth flow of foreign exchange for investment and other purposes permitted by law. Even though you're not sure, when you read it, you can see it sounds logical. Anyway, this answer is correct. That is one of the duties. Keeping a record of whether foreigners married to Sri Lankan citizens have stayed for more than 183 days in Sri Lanka during the preceding 12 months. Do you think that the central bank is jobless to maintain records of foreigners who are married to Sri Lankan citizens have stayed for more than 183 days? Central bank is not jobless to do something like this. So when you read it, you should be able to understand this is an odd answer that is not logical at all. So therefore, it's out. Providing the department's management with information and data to aid into the process of making macroeconomic decisions. This is correct. Right? Undertaking the continuous frontier research with a view to enhancing knowledge and analytical capacity in the area of foreign exchange management and related disciplines. That answer is actually correct. So you can see, except for the first two, the others have basically three answers. If you look at, okay, 2 cannot be there. 2 is, I mean, kind of a stupid answer. Therefore, if you're not sure about the answer, you can use the excluding technique. Now, whenever you have 2, you can remove it because 2 cannot be there in the answer D. Now you have to pick the correct answer from B and C. So the only thing that you have to check, B and C, now you have 50% possibility of getting the correct answer because Roman 2 is not a logical answer. The only difference between B and C is Roman 1 is not there in B. Then you read Roman 1, ensuring the smooth flow of foreign exchange for investment and other purposes as permitted by law. When you look at it, you will see there's nothing wrong with that answer, a logical answer. Therefore, you cannot avoid that. Hence, Roman 1 should also be there. Accordingly, 1, 3, and 4, the correct answer is. All right, so that's another way of getting the answer if you're not sure about the exact answer. Right. The fifth one, Sarwat Enterprises is to be incorporated under the Companies Act number 7 of 2007 as a limited company whose shares will not be offered to the public. If you are not offering it to the public, then what the company should be? If you're not offering it to the public, it has to be a private limited company and with a limitation on its number of shareholders. So either public or private. This is a profit-making business. Therefore, it cannot be a limited company by guarantee. One of the easiest questions. 2 marks, 3.6 minutes. It doesn't take even 10-15 seconds to get the answer. Once incorporated, it most likely name would be Sarwat Private Limited, Sarwat Limited, Sarwat PLCs. Sarwat Limited is a public company. There they can offer shares to the public. Sarwat PLC is listed in the Colombo Stock Exchange. There's nothing called Sarwat Public Limited. There's nothing called. So this is wrong. But if you look at the requirements here, they're not going to offer shares to the general public. So obviously, it cannot be Sarwat Limited. It cannot be Sarwat PLC. And there's nothing called Public Limited. That is also out. And obviously, it has to be Sarwat Private Limited. Easy 2 marks. So if you make a mistake here also, then that means you have to work really hard because then your knowledge is not sufficient right now. So you have to improve it. There's no magic. Until you study, until you make an effort, obviously, you're not suitable to sit for the exam because it's all your own effort will help you to get through the exam. Right? Then which of the above statements are correct in relation to overseas companies? We have already looked at. This answer you can identify from the Companies Act. We have already looked at, but now you get another question from overseas companies. Which of the following statement relates to overseas companies registered under the Companies Act 7 of 2007? Roman 1, all registered overseas companies must deliver certified copies of financial statements for each calendar year. To the registrar of companies. Please go through the relevant provision. To save time, I will straight away tell you whether it's right or wrong here. Yes, they have to provide the financial statement. So this is correct. This is correct. These companies are incorporated in Sri Lanka under the Act and have an established place of business outside Sri Lanka. We went through the definition little while ago. It's a complete opposite of that. These are companies incorporated outside Sri Lanka and have a place of business in Sri Lanka. This is the complete opposite. So it's wrong. Then the Act prohibits companies that do not conform to the stipulation made by or under the Foreign Exchange Act number 12 of 2017 from establishing a place of business in Sri Lanka. There is a gazette notification issued saying these companies cannot be done by foreign shareholders and foreign entities cannot be prohibited. So that is correct. So since you are a company incorporated outside Sri Lanka, since you are an overseas company, there are certain business activities that cannot be performed in Sri Lanka. Therefore, Roman 3 is also correct. Then List A of the Foreign Exchange Act. There's nothing called List A. You can go through the Foreign Exchange Act. Therefore, it's wrong. So it has to be Roman 1 and 3 only. So the answer is B. In the textbook, please look at pages 142 and 144 for further information, right? Then, which of the following statements is correct? Per the Land Rest Act, please you get one question. Sometimes there can be questions in section 2 also. But in this instance, we have only one question, right? Yes, I mentioned this, Naoda, to answering your question. These things will be uploaded, I think both YouTube and then again to their website also. You can double check with them. Definitely they will upload it. That is the purpose of recording these sessions. Anyway, which of the following statements is correct per the land restriction? So you definitely get at least a question for 2 marks, but my experience is in the past, they have given questions in section 2 also. This is a rare occurrence. There's a rare situation. You have been given only a question for 2 marks. Anyway, Land Alienation Act, again, is not an act that you can take with you to the examination hall. Therefore, you have to memorize these things. There's nothing much, little, but important. Therefore, memorize. Which of the following statements is correct per the Land Restrictions on Alienations Act 38 of 2014? Please go through section 2 of the land restriction, Land Restrictions on Alienation Act. Section 2 is an important section. So the answer is here actually. So please go through it, section 2 carefully. Now I will give you the answer. Where the title of a land. Now the whole purpose of this section is to restrict foreigners by acquiring properties in Sri Lanka. Foreigners cannot buy properties in Sri Lanka, but they can lease, acquire properties on lease for a maximum period of 99 years. You can go for a 99-year lease. Otherwise, foreigners cannot buy properties in Sri Lanka. Not only that, even a company, if the company is owned 50% or more by foreign shareholders, if the company is owned 50% or more by foreign shareholders, then again that company cannot buy properties in Sri Lanka because this company is controlled by foreigners. Therefore, that company cannot buy properties in Sri Lanka. So if you have a foreign shareholding, at the time of purchasing the property, the company secretary must inform the land registry that the shareholding is less than 50%. And every 6 months afterwards also, they have to inform the land registry, give an update about the shareholding of the company to say it has not exceeded, it is not 50% or more. Because if it exceeds 50 or more, then you can't own that property because it's prohibited. So those are the main rules. So where the title of a land is transferred to a Sri Lankan company that has more than 60% of a foreign shareholding, the secretary of that company has to submit certain documents. The latter part is correct, but the relevant percentage is not 60%, it is 50% or more. 50% or more. So please look at section 2 of the number 38 of 2014 Land Restrictions on Alienation Act. So this is wrong. Sri Lankan companies of which 50% or more of the shareholding is held either directly or indirectly by a foreigner are permitted to own a land in Sri Lanka. No, it's opposite. Prohibited. Not permitted, it's prohibited. Wrong. Sri Lankan companies of which 60% or more of the shareholding is held either directly or indirectly can hold a land. No, it's prohibited. It is prohibited. Not only 60%, even if it is 50% or more, you can't. So obviously, the last one has to be the correct answer. Foreign nationals and foreign companies can lease lands into Sri Lanka up to 99. They can't buy, but they can lease out. I mean, they can acquire the land or the property on lease for a period of 99 years maximum. So the correct answer is D, commonly tested area at the exam. So make sure that you are ready for something like that. Then only 3 more questions. So after that, we can wind up the session. Which of the following statements is correct about the ultra vires rule? What do you mean by ultra vires? It's a Latin term. Ultra means beyond. Vires mean power. Beyond power. Which of the following statements is correct about ultra vires? Ultra vires means beyond power. This is part of the company law actually. Now, those days under the old act, there was a requirement to mention the objects of the company. Objects of the company. If you state the objects of the company, then under the old act, the company couldn't do anything beyond the objects. Beyond the objects. Those days, when you mention the objects of the company, your power to do transactions were limited to the objects. So if you do something going beyond the objects of the company, they were ultra vires. But when they introduced 2007 Companies Act, they went away with that restriction. Now, it's not mandatory to have objects of the company. It is not mandatory to have objects. If you want, you can have objects. So now there are companies with objects mentioned in the articles of association, and there are a lot of companies without objects because it's not mandatory. If you don't have objects, anyway, you can do whatever you want. But if you have specifically stated these are objects of the company, still the Companies Act doesn't restrict you to do only transactions covered by the objects. Now, under the current Companies Act, though you have mentioned the objects in your articles, doesn't matter. You can still do transactions which are not covered by the objects. Therefore, the ultra vires principle is actually no longer applicable. So anyway, let's see the answers given. Correct statement. The ultra vires rule doesn't prevent companies from entering into contracts outside its objective that has specified in the articles. Doesn't prevent companies from entering into contracts outside its objectives that are specified. But if you look at the ultra vires principle, it says you can't go beyond powers. Here, the ultra vires rule says no, you can't go beyond. The objectives of the company are set out in the memorandum, and any act that is outside such objectives is held to be ultra vires, hence void. The Companies Act number 7 of 2000 continues to follow this rule. Absolutely wrong, false. This was the position under the old act. Now, it's not under the old act, yes, they were void. But under the Companies Act number 7, 2007, even though it's not covered by the objects, they are still valid. Anyway, I will please go through pages 160, pages 32 to 34 of the Companies Act. And the relevant section is this. I will give you the section also. There's a separate chapter for articles of association here. Section 17 here. The effect of statement of objects in articles. So this is based on section 17, but you don't have to mention the section here. You have to just pick the correct answer. So you will see, and anyway, there's nothing called Memorandum of Association. Under the new Companies Act, number 7 of 2007, there's nothing called memorandum. We have only the articles of association. Therefore, it is wrong. This is also wrong. This rule says that even if the objective clause of a company changes over time, the company is still prohibited from engaging in any business activities that is not mentioned in the original object clause. No, completely wrong, because the current Companies Act is very flexible. Though you do something beyond the objects of the company, still they are valid. So it has to be D, but anyway, we'll read it and see. The Companies Act number 7 of 2007 has granted the freedom, that's I told you, flexibility to engage in business activities without being restricted to the objects clause. Absolutely right. So this is the correct answer. Then, according to listing rule 7.6, now you can see it's not in the Companies Act. So you have to be familiar with it. You have to memorize it. No other choice. The item that must essentially included in the Astra's annual report are, but you can use your common sense also using knowledge gained from other subjects. Let's see. The following items have been included in the annual report of Astra PLC, a listed company. They're asking, according to listing rule number 7.6, the item that must be essentially included. Let's say corporate social responsibility. CSR is not something mandatory. Therefore, this is out. Names of persons who during the financial year were directors of the company, very important. Then, principal activities of the company and its subsidiaries during the year and any changes therein. Important. You can go through pages 168 and 169 of the textbook for further information. Then names and numbers of shares held by 20 largest holders of voting and non-voting shares of the company and the percentage of such shares. Now here, these things sometimes, this one, you can't pick using common sense. So you have to memorize chapter 9 and chapter 10, memorize them. So the correct answers are 2, 3, and 4. Accordingly, the answer is D. Answer is D. Here, if you do not memorize, then it's little difficult to get the correct answer, but you can increase the possibility of getting the correct answer because Roman 1 is not a mandatory requirement. It's a good thing, but not mandatory. Therefore, A is out here. Roman 1 is there. And C also Roman 1 there. Therefore, those two are out. So you have to pick the correct answer from B and D. D has Roman 2. But B doesn't have Roman 2. Names of persons who during the financial year were directors of the company. So if you add little bit of common sense, you should know it is an important information. Therefore, 2 should also be there. So by using an approach like this also, you can get the correct answer if you are not sure about Roman 4. Because to get Roman 4 right, you have to memorize it. Otherwise, you will not be able to I see whether this is correct or not. But using the approach that I explained here also, there's a possibility of getting the correct answer. So don't give up, even though you can't remember. Just see whether you have an odd answer and remove it from the given answers and see whether you can increase the possibility or the percentage of getting the correct answer. I mean, no harm doing that rather than just picking an answer. Right? Then finally, another question from there. Rule 7.10 of the listing rules of the Columbus Exchange, known as corporate governance. But under this rule, it is mandatory for listed entity to have certain, since you guys are doing subjects like audit and assurance, definitely you must be familiar with it. You don't need law knowledge to answer this question. Have certain committees ensure the independence of the entity. What are those committees? Which of the following are one such committee? Under corporate governance rules, there's nothing called accounting committee. There's nothing called corporate disclosure committee. There's nothing called minimum public holding committee. Obviously, as audit and assurance student CL1, you guys are familiar that the main committees are audit committee, risk management committee, nomination committee. Those are the committees that are required under corporate governance rules. Audit committee, nomination committee, risk management committee. So those are the main committees actually. Therefore, even though you haven't gone through the textbook, the relevant part, still you should be able to get the correct answer here. Easy, 2 marks. So answer is A. So with that, we will conclude the session. But before winding up, I must thank Aruna from the Chartered Institute for the support that he gave me, and the Chartered Institute for giving me this opportunity. I must thank them. And at the same time, if you have further, if you require any further clarification, you can email me on this email address, jrj.attorney, ATTORNEY @gmail.com, right? So you can reach me through this email address if you need further clarification. And with that, we will wind up this session. And I wish all of you the very best, and may all of you get through not only this paper, all the other papers that you do, and all of you should be able to become fully fledged chartered accountants as soon as possible. Good luck, guys. Once again, wish you all the very best. Thank you very much.